I seek my lord's indulgence to make a mention of two contempt petition. Lordship, item 2 and 3, it's listed tomorrow before your lordship. The APSC series matter. Item in tomorrow's list, lordship, item 2 and 3 is listed. Those two petitioners, Priyanka Deka and Jayantu Dole, have filed contempt petition as well. So if it can come together tomorrow.
No, it can't come.
Lordship,
Contempt, I'm not taking up.
lordship, the
No. And mention it before quote number 5. If he permits, I'm not to take any mention on this for listing. Quote number 5 may help you out because he's bench 5. I'm bench 4 and 5.
the issue is
I understand that.
Yes, Lordship.
But my question is before that, the matter which is heard before me is not the contempt petition.
No.
So the only I'm taking up I think there's only one series
Yes, Lordship.
tomorrow. Other matters I'm not taking up.
Yes, Lordship.
It would not also be proper on my part to take it up, taking into account our resolution, not to take up other matters which are not fixed. We'll take it up later on once it happens. You
Very-
mention it tomorrow.
Oh, very much.
Well, Lord's permission, may I mention item 34, 34. Well, I have instructions to withdraw this matter. Nothing remains. I have informed the others.
Your name?
K. Talukdar.
Mr. K. Talukdar, the learned counsel appearing on behalf of the petitioner, who submits that why it has become infructuous?
Nothing remains. It was tender which I challenged my
I have
rejection.
challenged the tender. I challenge the award of a tender. And in the meantime, the writ petition has become infructuous. Taking into account the above, the writ petition therefore stands closed as it has become infructuous.
I am good.
Interim orders, if any, stand vacant.
My lord, item number 3, my lord, this matter is becoming infructuous.
Mr. J.C. Bora, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous, and accordingly, the instant writ petition, the petitioner would not therefore like to pursue with the instant proceedings. Taking into account the above, the instant writ petition stands closed. Interim orders, if any, stand vacated.
Your lordship, I have to mention item number 31, my lord. But are already complied, my lord.
Contempt case, no? 31.
Order dated. Order dated, complied with. We'll have to see, na? When a matter reaches.
It's complete on. Who's there? Yes.
What are you challenging?
My lord, order dated 28/2025 may be perused.
Why you are challenging?
Challenging because, my lord, we took that order from Tahikusi Panchayat.
No. Panchayat has no business out there to give away here. Does it fall within the GMD area?
Yes.
Matter of
Yes, my
what is there?
my lord.
First, they have to take out a planning permit. First, they have to take out a planning permit because it is completed in the zoning regulation of the GMD. Thereafter, the Panchayat will issue the issue.
My lord,
The NOC.
in the order 28, 2025, this honorable court has given some instruction to that council.
What?
May I read the second paragraph, my lord?
Where? Order dated?
28, 2025.
28, 2025.
Yes, my lord.
What is that?
Order dated 28, 2025. Madam, may I read this?
Yes.
Mr. S. Bora, Land Council representing the respondent number 2 shall receive instruction as to whether the building constructed by the petitioner basing on NOC issued by the Kahikusi Gaon Panchayat in the year 2001 without a prior approval from GMD authorities can now be regularized and shall apprise the court about the same on the next day.
No. How can he say anything? Because nothing has been done as regards regularization. You cannot regularize anything.
My lord, the conducting council, Mr. P.
No,
Bhardas is-
conducting council, no council hardly
lord, it
matters. The
may be
thing
fixed on
remains,
Monday, my
the
lord.
Act of 1985 does not provide any regularization as regards construction made without building permission. Does it?
My lord,
Does it
may be
regularize?
fixed-
No, you cannot.
First, you have to apply. The application has to come.
My lord, can it be fixed on Monday for that?
Why?
For submission of that conducting council.
Huh?
P. Bhardas is out of station today, my lord.
Who is P.
He's
Bhardas?
conducting council is.
So,
So maybe on.
I'm not
Monday.
extending the interim order. Go and demolish it. Demolish. You need time. How much? How much time do you require for demolishing?
Demolition, it takes time because
1
you have to
month?
inform all the police station.
2 months?
Not to 1 month, 1 month, but you have to inform the police
Okay,
station
1
and get the
month.
help of the
Okay,
police
we have it after 1 month. In the meantime, you demolish it and give us the
My
details.
lord, it will be fixed on Monday, my lord, for the submission of my.
No,
The last chance may be given, my lord.
that stands no chance. Anyway, there is no interim order passed. From 26 to 2026, there is no interim order passed.
My lord, is just conducting council just inform me to submit before this honorable court.
Your
to take-
conducting council also knows that it is a very difficult thing to get that thing.
No, my lord, he will submit on Monday. But therefore, my lord, it may be fixed on Monday. It is my humble request, my lord.
Heard Mr. S. Bora appearing on behalf of the GMDA, who submits that the impugn order dated 23/8/2018 requires no interference, taking into account the admit stand of the petitioner that there is no permission or approval taken from the GMD authorities. Mr. So-and-so appearing on behalf of the petitioner submits that a further chance may be given to the petitioner to make submissions in the instant writ petition. Taking into account the above, list this matter on
Monday, my lord.
Monday.
Always, my lord.
May I please your lordships? My lord,
What is this IA business?
IA is for substituting the respondent number 6, my lord. That has been allowed. And notice service is completing.
Who is Gautam Bora?
Gautam Bora is the LIC agent, my lord, through which the policy was done, my lord.
Then why the substitution?
Because earlier, my lord, by misrepresentation, another person was added respondent number 6, my lord. One Abhijit Borua. So he was not the person who did the, my lord, policy of the father of the petitioner. Subsequently, the Abhijit Borua filed an affidavit before this honorable court stating that he was not the person through whom the policy was done. And that's why, my lord, the Gautam Bora.
No, why you are making him a party by name?
My lord, the issue is that, my lord, at the time of purchasing the policy, some questionnaires were put, my lord. That is the issue, my lord. And it is the claim of the petitioner that, my lord, that questions were not answered by the father of the petitioner. That is one issue, my lord. And another issue is that, my lord, the policy the insured person died after expiry of 2 years of the policy, my lord. So
Where's the impugn order?
impugn order.
Your
has
claim under
paid,
the
my lord,
policy of the appointment, so we have informed you that you have decided to
21, my lord.
repudiate all liabilities under the
Page
policy
21 and exercise 6, my
of
lord.
the deceased having withheld material information regarding his health that informed the to keep the further. Now, the reason for which it was the policy was repudiated, can this court decide this? Isn't it a question of fact?
Section 45, my lord. Section 45 says that after expiry of 2 years of the policy, death questionnaires cannot be put to question, my lord. Before the completion of 2 years, that may be a disputed fact. But section 45 says, may I read section?
When did the person die?
The person died on, my lord, 14/2/2013.
14/2/2013.
Yes, and commencement of the policy is 29/12/2010, my lord.
29?
12/2010.
Okay. Policy was taken on 23/12/2010.
Yes, and commencement of the policy was from 29/12/2010.
Commencement of the policy,
Yes, my lord.
29/12/2010.
Yes,
And
page 15, my lord.
he died on 14/12/2013.
14/2/2013.
Into 2013. Okay, show me that provision. Which provision? Consumer.
Yes, my lord. Insurance Act, section 45 of Insurance Act, my lord.
LIC.
Insurance Act, 1938, my lord. Your lord.
Which provision?
Section 45, my lord.
This is after 3 years.
Yes.
Person died when?
14/2/2013.
Earlier it was 2 years. Now it is 3 years.
2013, that point of time, my lord, it was 2 years, my lord.
No, this is again a question of fact. Read the provision. This exception of 2 years is subject to to the insurance company, insurer, on the ground that a statement made in the proposal for insurance or in a report of the medical officer or friend or any document to the issue of the policy was inaccurate unless the insurer shows such statement was on the material matter or suppressed fact which it was material to disclose and it was fraudulently made by the policyholder and the policyholder knew at the time of making it that the statement was false or it suppressed fact which it was a material to disclose. Now, whether it is material or not, can this court decide that?
Your lordship may refer to the questionnaire. My lord, what were the questions put, my lord?
Yes.
The impugn order, my lord.
Yeah.
Because now they are saying that because the
Are you suffering from or you have suffered from diabetes, tuberculosis, high pressure, cancer, so and so, or any other disease? You said no.
no,
Now, we may, however, state that all these answers were false, as we have evidence in here that believe that so and so was suffering from hypertension, for which he had taken EOL and HPL, and all were taken prior to the date of commencement of the policy. He, however, did not disclose the correct information in the proposal to us. On the other hand, he induced us to issue the above-mentioned policies on a false statement made by him in the proposal statement. Had he disclosed the correct information, we would not have accepted the proposal. We have therefore, in here, repudiated the claims. So this is a question of fact.
my lord, they are because they are making this statement on the basis of the EOL and HPL availed by the petitioner. EOL means extraordinary leave and HPL half pay leave, my lord. Only because of that, my lord.
So isn't it a material question that you were suffering from hypertension?
No, my lord.
Why?
Because otherwise.
He died out of cardio.
Yes, my lord.
See, it's a cardiorespiratory failure,
Yes, my lord. That may
acute
be.
so and so hemorrhage.
Otherwise, he is an athletic, my lord. Page 3, your lord, annexer 3, your lordship may refer, my lord. He has participated in the National Masters Athletic Championship in the year 2012, my lord.
Who?
The father of the insured person. Page 18, my lord.
This is Krishna Bora.
Yes, my lord. He is the insured person. Father of the petitioner. If he were having this kind of illness, how he could have participated, my lord? He was the active athlete, my lord.
What was his age of at the time of death? 53.
Yes, my lord.
So this is a question of fact.
In the year 2012, my lord, he participated in the 33rd National Masters Athletic Championship in the age group of Masters Men M50 plus. Age 18, my lord, and except 3, my lord. Cardiac arrest may be sudden, my lord.
You see, other significant conditions, essential hypertension. Merely running a race out there doesn't make that you are not having hypertension. Mr. Chaudhary, you are there for whom?
For the insurance. We have raised the preliminary objection with regard to the disputed question of fact.
It's a question of fact. In fact, this is a question you should go before the
Exactly.
consumer forum.
Exactly, consumer forum. We are staying on that.
Not here. Go there. And why should we make him a party? The moment you are relying on this particular section 45, that number 6 has no value. Your question is that he put this, he filled up the form and said no, isn't it? Now therefore the submission is here. Then look here, irrespective of whether he has filled up the form or not, you cannot take into consideration a statement at the time if it is issued prior to 2 years. Then why is that response substitution necessary at all? It makes no sense on that. But Mr. Bora, you cannot come here because this is a question which I cannot decide. I have all sympathy for you, but I can't decide this aspect. This is to be decided either by the consumer forum or the insurance ombudsman. Now, insurance ombudsman period is long over, taking into account that it should have been here. Now,
Consumer case also the period is longer. The repudiation was not.
No, taking into account that the petition was filed here, we do one thing.
Otherwise, that
No, we do one thing. We send it to the insurance ombudsman to decide.
because that hypertension, how they can determine now, my lord?
Understood. Let that insurance ombudsman decide, and thereafter you go to the consumer, whatever may be. I leave a way out, but this court cannot decide. Problem lies there. Because I cannot decide. That is why the writ petition is pending from 2016.
It has not been listed for a long time. It was not listed also, my lord.
That is why I think this is the only way out. Or you want a dismissal? I can give you a dismissal on the face.
I just want some relief to the petitioners, my lord.
Petitioner's relief
Somehow,
is
my lord,
there, but can't help you with the relief. I can't give you that relief because he is not going to rely on the first part. He's going to rely on the second part. Now, the fact that he has run a race is a question of fact.
But
Running a
hypertension-
race, there are many people. I have seen there was one gentleman who's a very close friend of ours. He was 78 or 79. He used to run a lot of race.
because the
And then one fine morning, I hear that he died out of heart failure.
yes, my lord, that happens sometimes, my lord. But
So that might not be a cause, but for a court under 226 to look into it.
but the basis on which only because the insured avail EOL and SPL. That's why they have assumed that he was suffering from hypertension or some kind of a illness, my lord. Only that is their assumption.
No, from your own certificate, the death certificate itself shows the essential hypertension. This document is there. Forget about EOHL. Annexure 4 says that essential hypertension. Obviously. So whether it was there at that point of time, did you take the leave on those basis? These are questions which you have to show it before the authority. You saw that these leave which was taken prior to your 2010 insurance policy came into effect on 24/12/2010. Prior to that, whether why did you take that EL or whatever may be? Was it just for the sake of it, or was it on account of hypertension? Did you make your own your employers a party here? Why? Because they would say that these EOL, EL or HDA, EOL and HPL was not taken for anything else.
That is because for LD2 that could have been a medical relief, my lord.
So medical relief if we had taken for hypertension and then you have not disclosed it, obviously the insurance of contract has to be violated. And if it was material, whether it is material or not, is not a question, it's a question of fact.
But that burden lies on the my lord insurance because they are alleging only because of the HPL and EOL. They are just assuming that the petitioner was having the ailment, my lord. They are assuming only because of that, my lord. In this regard, I would like to refer one judgment, my lord. Yep. Contempt Perus, para 15, 16, 17, my lord.
You have not filed your reply also. The affidavit. Well, they are saying out here that that was a material question. You have not referred also, said denied to that effect also.
But that material question, whether that is relevant or not, my lord, to the death of the petitioner, my lord. Insured person, my lord.
There is no reply also.
The lordship, may peruse the judgment, para 15, 16 and 17. The judgment of the defendant.
Then you come to paragraph 17.
Yes, my lord.
Read it.
In the present case, the insured admittedly died on so-and-so due to heart failure, and there is no material on record or any medical evidence to show that the insured had suffered from any serious disease affecting his life expectancy in any manner prior to his taking the said three policies. The medical book maintained by the employer of the insured disclosed that he had complained of lower back pain in the year 1999, which was non-specific and no neurological order or deficiency was noticed, and the insured did not suffer from any serious disease or illness during his service period. Merely because the insured had not disclosed in the proposal form some minor ailments of trivial nature suffered by him temporarily on some occasions, as it has been reflected in the medical book of the insured, which had no material bearing on the risk undertaken by the LIC or even any remote nexus with the ultimate cause of his death. The same cannot be construed as fraudulent suppression of material facts.
Okay.
So as
Now, come back to this. Running page 31, paragraph on review. Running page 31.
paragraph.
There's no paragraph. Insurance, they don't think of putting paragraph. It's a part of paragraph 7.
Yes, my lord.
On review in our claim processing.
Yes, my lord. The policy duration from so-and-so is 2 years, 1 month, and the cause of death was CVA, acute left cerebral hemorrhage with intraventricular extension with subdual collection. As per the leave particular certificate as provided the DLA employer ONGC Limited, Assam Asset Drilling Services, the following fact is revealed the truth. From leave record, it is seen that DLA availed EOL and SPL in different date in many times. Application for SPL from so-and-so for self-illness, accident on duty. That accident, as per certificate issued by the so-and-so drilling services dated 10/4/2024, reveals that on 11/11/2010, while drilling well so-and-so, a fatal accident occurred on rig number so-and-so, and it greatly affected late so-and-so, and he went into shock, and to recover from the shock, he took SPL from 11/11/2010 to 30/11/2010. He did not receive any physical injury, only affected by the tragic condition of his colleague.
Next.
As per history sheet of Srimanta Sankadev Hospital, dated so-and-so reveals that the DLA was a known patient of HTN, not on medication, and he was admitted in the hospital on so-and-so, and he was referred by neurosurgeon with a so-and-so fall from bed 4 days back in a drunken state. In view of the above finding, the statement made by DLA at the time of proposing for insurance of 20 lakhs is suppressed the material information of SPL and EOL. And he also concealed the information regarding his
Why are you not filing a reply? File a reply there. You see, their basic information, these three.
Yes,
Okay. There was an accident. There was no physical injury. Mentally, he was disturbed. This is it. This is prior to the taking of the policy.
Yes.
Policy was taken on 24/12/2010.
Ten.
The subsequent thing of 2013, has no relevance, taking into account that this happens subsequently.
Yes.
Why you are not filing a reply to
Yes,
this?
my lord, I'll file. Actually, I talked to my colleague also that we should have filed a reply.
Then why you are spoiling the time of the court on this aspect? You file a reply on these two,
Yes, my lord.
because this is the allegation.
Yes, my lord. I'll
And
file.
then say that this doesn't amount to suppression.
Yes, my lord.
Yes, there might have been subsequent. Subsequently, you may have been in a drunken state, neurological problems may happen later on. But there is no evidence that prior to that there was,
Yes.
except that I had an accidental fall. And there it is their self-admission that there was no physical, only affected the tragic condition of his colleague, that he was mentally depressed.
Yes, maybe normal, my lord, when he saw.
Mentally depression
Yes.
cannot be a case of hypertension.
Yes, my lord.
So therefore, there is no sub. Yeah. So file a reply to
Yes,
that
my
effect.
lord.
Then you will help me out in
Yes.
getting that order.
Yes, my lord.
Mr. BP, we close the other one.
Yes, my lord.
The IA has
Yes,
no
madam.
value. Mr. BP Bora, the learned counsel appearing on behalf of the petitioner, submitted that taking into account that the petitioner herein are claiming their rights under Section 45 of the Insurance Act 1938, the instant application to file for substitution of the respondent number 6 is not pressed. Accordingly, the instant application stands closed. This is there. Main petition. Heard Mr. BP Bora, the learned counsel appearing on behalf of the petitioners, and Mr. SP Chaudhary, who appears on behalf of LIC. It is the case of the petitioner herein that the repudiation so made to the insurance claim by the respondent LIC is contrary to Section 45 of the Insurance Act 1938, inasmuch as the insurance policy was effective from 29/12/2010 and the death of the death of late Krishna Bora occurred on 14/2/2013, which is more than 2 years, 1 month. Mr. BP Bora, the learned counsel appearing on behalf of the petitioner, further submitted that at that relevant point of time, Section 45 of the Act of 1938 clearly stipulated that a policy shall not be called in question on the ground of misstatement after 2 years. The learned counsels further submitted that the repudiation of the LIC policy by the respondent LIC does not merely makes vague allegations of suppression of material facts. The learned counsel submits that material facts, there would be suppression of material facts, which is a material suppression of a material matter has to have a correlation with the cause of death of late Krishna Bora. Referring to paragraph number 7 of the affidavit in opposition filed by the respondents, the learned counsel submitted that The reference so made to the various leave sought for by late Krishna Bora during his lifetime prior to the commencement of the policy does not speak anything about hypertension, which is the reason for which he expired subsequently, as would be seen from the death certificate. He, however, submits that taking into account those allegations, it would be proper on the part of the petitioners to bring on record their stand by filing an affidavit in reply to the affidavit in opposition filed by the respondent LIC. So, taking into account that the petition has been pending for more than a decade, this court fixes this matter again on 30/3/2026. In the meantime, the reply be filed on or before 24th of March 2026. So, the manner in which I have dictated the order, put your affidavit in reply in that.
Yes, madam. Deeply okay.
Lordship pleases. I am appearing in item number 4, my lord. Lordship pleases. Am I audible, your lordships?
Yes.
Am I audible, my lord? I am appearing for the petitioner, my lord. I am appearing for the petitioner, my lord.
Put the mic a bit down. Yes.
Am I audible, my lord?
Lordship,
I had
yes,
requested for it.
yes,
I
Mr.
am my
Bhupan, I
apologies,
see
my
you
lord.
there.
I am actually couldn't be physically available because I am not well. I have
Can
a
you
very bad
increase the
throat.
volume? We can't hear Mr. Bhupan from there.
No, I have a problem with my voice because I have a very bad throat and a viral. Like that's why my voice is not very clear.
I
I
thought
think, my
that
lord.
the problem was the equipments, not your voice.
No, my lord, I think it is my voice because I have a very bad throat. I've been suffering from for last couple of days. That is why my voice is not very clear. My apologies. I could not be there physically, my lord. This matter
Okay.
arises out of the
It has been
DRT proceedings,
submitted
my
by
lord.
Mr. R.B. Phukan, the learned counsel, appearing on behalf of the petitioner, that he is having acute problem with his throat, and as such, request for an accommodation.
I'm
Mr.
extremely
Ganguly,
grateful.
what is your stand?
No, this matter would require some hearing rounds.
Mr. A. Ganguly, the learned counsel, appearing on behalf of the respondents, however, does not oppose, but submits that as there is an interim order operating, the matter be taken up for disposal at an early date. List this matter on 26th March. I hope,
Yes.
Mr. Phukan, by then either you are okay or change the counsel.
I should be. I should be available, my lord. I should be 100% available.
List the matter again on 26th of March 2026 for final disposal.
I'm extremely
The
grateful, my
interim
lord.
order passed earlier will continue till the next date. It is observed that in the circumstance, Mr. Phukan is not in a position to argue the matter on the next date. The petitioner shall make appropriate accommodation arrangements.
I am extremely grateful, my lord. Extremely grateful. Sorry for the inconvenience.
Lordships.
Yes.
Lordship, if I may take your lordships to the order dated 7/8/2024.
7/8, where is that? What are you challenging here?
Lordship, I am simply claiming refund of the amount which has been deposited with the bank 11 years ago, that is way back in the year 2014. And the amount was deposited for since I was a successful bidder in an auction whereby a plot of land was being sold. The entire amount of 55 lakhs had already been deposited before the bank in December 2014. Even thereafter, they made several attempts to hand over the possession of the property to me till 2016. It has not been done. In 2017, a money suit was filed before the Learned Court of Civil Judge, but subsequently, since a similar matter was decided by this Honorable Court, on that ground, the money suit was withdrawn in the year 2022 December, and thereafter, the instant writ petition has been filed. On 7/8/2024, your lordships had given liberty to the bank to refund the principal amount. The said amount was not refunded. Thereafter, another coordinate bench of this Honorable Court was about to give liberty to them to refund the principal amount. But when I pointed out that this Honorable Court had already given liberty 6 months prior to that particular date, that is why on 29/1/2025, this Honorable Court had directed the respondent bank as to why the bank should not be directed to refund the amount of the petitioner forthwith and pay an interest at the rate of 8% per annum.
Who has directed?
This Honorable Court by order dated 29/1/2025. Honorable Mr. Justice Karda Kete. Taking into consideration the order which had been passed by your lordships on 7/8/24, that liberty had already been granted by this Honorable Court, but the bank did not comply.
Then
Thereafter, lordships, there was no board of directors in the bank. As such, the corporation department, the registrar of the cooperative societies, was taking care of the management of the bank. As a result of which, by order dated 9/5/2025, the respondent.
yes, I understand this matter. Yes.
Facts and who has come. In fact, there are so many facts for the table for a lot. It's convenient. What is the other party suit is going on? Basically, relief that there is a invention, and we just come in the way. A lot of suit
Regarding that title suit, your lordship has already recorded in the order dated 7/8/2024.
But have you issued a certificate of sale?
Only sale certificate,
Yes.
but no sale deed has been executed.
Sale certificate issued. Only possession could not be handed over due to that, my lord.
And you are a party in that proceedings?
No, my lord. What has happened, my lord? One investor colleague, I have stated, my lord, here. My lord, he had filed the civil suit saying that there was a, my lord, agreement between the mortgager, the borrower, and him. And thereafter, my lord, after the sale notice was issued, or the possession notice was issued, it was issued in 2012. Thereafter, he came before the court in 2013. So, SARFC proceedings, my lord, was already initiated. Now, thereafter, my lord, his suit was dismissed for default. And thereafter, my lord, several, my lord, attempts were made to hand over, my lord, the possession. But that could not be made, my lord, due to certain, my lord, what to say, my lord, the mortgagor, my lord, was in occupation of the land with some cattle and all. And several letters were written to the deputy commissioner also, intimated to the police also. This attempt failed. Thereafter, again, my lord, the suit was restored and injunction, my lord, was, my lord, is going. Injunction is again restored in 2025. I have given the facts, my lord. The suit dismissal order is revoked in 28/5/24. And again, my lord, injunction is made absolute. So this has come in the way.
The injunction is against whom?
Injunction, my lord, is issued against, my lord, for not alienating the property.
Against whom?
The mortgager.
Mortgager.
You are not the mortgager. Why you are not giving? Why you are not selling it? I don't understand. Because you see, injunction, it cannot, it would be always in personam.
Sale certificate already issued, man.
Sell it. There's no problem on your part to issue this, make the sale deed. And in fact, if you see the income tax rules, there's a schedule to the income tax rules by which the moment a sale certificate is given, the sale certificate takes the flavor of a sale deed.
Now, my lord,
Where is the land? How much is the land?
Lordship, 2 kathas.
Where?
2 kathas with 1 Assam type house standing thereon, covered by so-and-so, at village Madangaon under Moza Beltola in the district of Kamrup Metro, Assam.
Why you are asking for 55 lakhs? Fight it out.
Correct.
This is too pricey. Yeah.
Lordship, I have prayed for interest, and subsequently, because of the
The
conduct,
interest would be insufficient.
Lordship, because of the conduct of the respondents, I have also made a prayer. I have submitted one judgment before this honorable court on a previous occasion, the Pioneer Urban Land and Infrastructure Limited. Apart from that, there is one more decision, Lordship. This clearly says that if I may take your Lordship to page number 10, para 12.
Yes.
Lordship, the quoted portion, para 9, the last line, in cases where monies are being simply returned, then the party is suffering a loss in as much as he had deposited the money in the hope of getting a flat or a plot. He is being deprived of that flat or plot. He has been deprived of the benefit of escalation of the price of that flat or plot. Therefore, the compensation in such cases would necessarily have to be higher. So I am praying for compensation as well.
This judgment is not applicable.
The possession has not been given.
This is a different. This is a case of a different. Here you are an auction seller, purchaser. Auction purchaser's right is a different from that of a person having an agreement for purchasing of a flat or something. How is it relevant? But Mr. Talukar, I don't understand your thing of not granting the not executing the sale deed.
If I may,
Still need, my lord,
There's no bar on your part. I think you people have not gone to a good civil lawyer.
Lordship, if I may just take your Lordships to page number 112 of my rejoinder.
Where is the injunction? If you are not a party there,
yes,
there's no injunction.
not at a party. Bank has recently entered into, my lord. Bank was also not made a party. Recently, bank has entered into.
And where's the bank here now?
It is not, my lord.
They have not been appearing for the past few
And
days,
in fact,
Lordship.
my lord, what I'm submitting,
Now they have already a board of directors.
yes, they have already a board of directors.
So now your role is over.
My
Yes,
role is over. That is why, my lord, and I have received the instruction also that we have nothing to do. But as an officer of the court, my lord, I have made put the facts in the table so that your lordship finds it convenient. There are so many facts, my lord.
The
That is
facts
good.
are okay, but the fact is now the bank has become a party.
Yeah.
Now the bank is not before this court.
Bank is a party, my lord, here. Today, bank is not represented.
for the past
Counsel.
few dates, nobody is
In fact,
appearing
my
for the
lord,
bank.
in the title suit, perhaps compensation can be granted by the court to the Dimbeso Golita who had executed, my lord, the agreement with the borrower. That can be granted to him. He can get the relief and the land can be handed over to the petitioner. So I think, my lord, that would be the proper course of action. Instead of asking, my lord, because these banks are not, my lord, financially sound.
Why you are not getting yourself implemented in the suit
Lordship,
and filing these type of petitions? You should file that you are a purchaser now. You are an auction purchaser. By you see the auction purchaser
Satisfactory,
comes on the basis of the income tax rules. The rights are conferred.
Lordship.
Schedule 2, I suppose, of this income tax rules 1962. Look into that. You should enter into the fray and fight it out and get the sale deed. Why you are asking out here? There's a
Lordship, when
surfacing
the title-
proceedings. In pursuance to a surfacing proceedings, when there is already steps being taken, unless you challenge the surfacing proceeding, he has no right.
Lordship, when the title suit had already been dismissed between the mortgagor and
Madam,
Mr.
nobody
Bismuth,
can help you with this case. Even I, if you don't understand what this court is.
I understand what has fallen from your Lordship.
If you are only on that 55 lakhs, wait for another 10 years.
No,
You
Lordship.
should issue rule and keep it pending for years, 2 years and years till the disposal of the suit. Or should we make that this matter to be listed after the disposal of the suit?
No, Lordship.
That will be better.
Lordship, I'll just seek instructions,
You are
Lordship.
not advising your client properly. Why are you
Lordship,
fighting this type of litigations here? This court has no business out here. Can Anyways, Mr. S.K. Talukdar, Learned Standing Counsel of the Corporation Department submits that the respondent number one,
Kindly take note of the communication by the registrar. That now it's a matter between the borrower, the petitioner and the bank. That communication.
submits that the respondent number one, the board of directors of the respondent number one have been reconstituted, and the management of the respondent number one is now being run by the board of directors. Taking into account the above, comma, it is the opinion of this court that now the present proceedings has to be proceeded against the respondent number one and two.
That regarding the board, that has to be confirmed by the bank, my lord. What the board is now, whether it is functioning on
Are you still functioning under 41(6)?
that instruction, my lord. But here your lordship will say instruction is not in that regard. It's something else, my lord. So that confirmation, my lord, it's difficult for me, my lord. It will be amounting to make a wrong statement, my lord, for the honorable court.
No, you were brought within the fray out here on the basis that you are a, you are running the affairs under 41(6).
No, normally, my lord, the registrar is made a party because all the banks are under the supervision of the registrar.
Understood.
In that capacity, my
That
lord,
is a different aspect.
yes.
But are you still running it under 41(6)?
that aspect, my lord, I have to confirm, my lord. I
You
don't-
just said that the board of directors have been formed.
No, my lord, in fact, the bank will be the, my lord, right, my lord, the counsel for the bank will be the right person, my lord. On this count, my lord, I don't have the exact. After some time, your lordship may take up, I'll confirm. my lord.
No.
over
This
telephone,
type of matter.
After 5 minutes, my lord.
No, 5 minutes.
Let me get the instruction, my lord. Now, right now, my lord.
Level people heard Ms. P. Agarwal, the learned counsel appearing on behalf of the petitioner. Mr. S.K. Talukdar appears on behalf of the corporation department. Poster. An instruction has been placed before this court by Mr. S.K. Talukdar to the effect that the dispute between the petitioner, the dispute is between the petitioner and the respondent number one and two. And the register of cooperative societies have no role to play. This court has perused the various orders which have been passed in the instant proceedings. And the perusal thereof reveals that the management of the respondent number one was taken over by an officer appointed under section 41(6) of the Assam Cooperative Societies Act 2007.
2007.
Under such circumstances, still the management of the respondent number one is controlled by an officer appointed by the Register of Cooperative Societies, comma. The Register of Cooperative Societies cannot say that they have nothing in the instant proceedings. It is also seen that the respondent number one and two is not being represented. And there's an approval given of the year. Why are you, Mr. Talukdar, you are not aware of these matters? This is a document which is already there, given an approval of the proceedings of the AGM. It is a part of the record. With reference to, I am directed to convey the approval of the register of heir to the proceedings of the AGM, which means the board of directors have already been formed.
I remember when certain litigations were going on, only to that extent, my lord, I want to obtain the instruction.
It is there, this document is there, the approval. Once the approval has been given by the cooperative register of cooperative society, then the board comes in. This was given as far back as on to the year 2024.
Is your lordship talking about the letter dated 9/10/2024?
No, 25/9/2024. Where there is a declaration of results is also there given by the returning officer to the AGM.
Lordship, subsequently, there is a letter dated 9/10/2024 at page 163.
On
163.
where?
Lordship, this was
And
an
sir, 5.
affidavit filed, annexure 5, page 163. There was a dispute between the board of directors.
Because it is seen that the respondent number 1 and 2 is, however, not represented. So the petitioner is directed to take steps by way of dusty upon the respondent number 1 and 2. So it is observed that in the circumstance, the respondent number 1 and 2 is still under the management of the officer appointed under section 141(6) of the Assam Cooperative Societies Act 2007. The petitioner shall effect service by way of dusty upon the said officer. To list this matter again on 6th of April 2026.
Could it be on 7th of April? Could it be on 7th of April, Lordship?
What?
Can the matter be on 7th of April, Lordship?
7th? No. You want it 8th?
8th, Lordship.
8th of
Obliged, Lordship.
Yes, Mr. What is the matter about?
Matter is about, Lordship, the petitioners have let out the first floor of the RCC building to the bank, the State Bank. Then the bank was depositing the rent in the bank account of the petitioner number 3. Then all of a sudden the account has been held up, Lordship, without issuing any so-called notice, Lordship, without getting me.
Which order you are challenging?
So the informed order is, Lordship. Annexure 9, Lordship, page 85.
8? Page?
85, 85.
Who are you?
I am the landlord. Petitioner number 1 is the widow and petitioner number 3 is the son of the widow lord. They don't have any other.
And who is Suman Talukdar?
Suman Talukdar was the predecessor intent, that is the husband of the petitioner number 2 and father of the petitioner number 3.
And petition number 1 is?
Petitioner, the mother, she expired, so her name has been struck out.
Petition number 1 expired.
Yeah.
So petition number 2, 3.
Two is the widow
And the dispute is with whom?
Pardon.
Dispute is with whom?
Dispute is with the private respondent number 3, lordship, who after receipt of the summons did not appear and did not file any affidavit. Opposition.
And what happened? The suit has been disposed of.
Suit going on, lordship.
Suit is going on.
Suit is going on, lordship, but
Where is the plaint?
plaint, lordship, page.
You have filed the suit.
I have filed, lordship, the respondent number 3. She forcibly occupied the ground floor of the RCC building. She has a, she is in the habit of occupying the other property and other persons' plots were also occupied. Lordship. So I filed a suit for declaration right title interest recovery of possession law.
And she has not appeared in that suit.
She has appeared in the suit, lordship, and
And
the court granted a injunction in favor of the petitioner, lordship, directing the defendant of that suit not to alienate or change the nature and character of that injunction.
then why have you made the entire land disputed?
Lordship,
She has only trespassed into the ground floor.
only ground.
But why have you made the entire suit, the entire land disputed?
Lordship, the first
You
floor
are
is,
asking for right
the
title
first
in
floor-
interest of the Schedule A land.
first of all, lordship, she occupied the ground floor. Thereafter, first floor is in the possession of the bank as a tenant. And second floor is incomplete, only the roof was casted. There was a watchman, lordship, so he was also evicted from there, and the respondent number 3, lordship, occupied the second floor also. That's why the entire.
Now she has filed a counterclaim.
She has filed a counterclaim, lordship, for declaration of her right as a second wife of late Suman Talukdar. And the civil court, your lordship, fully aware, does not have the jurisdiction to decide. That matter can be decided only by the family court. Section 7 of the family court is a specific bar. So that counterclaim is also not maintained.
Then what happened to the suit?
Pardon, Malu.
What happened to the suit?
Suit is pending, lordship. Evidence has been filed from the side of the plaintiff. Since last, your lordship, in the bank account, 65 lakhs rupee has been deposited in my account, in the bank account of the petitioner number 3, but I am not allowed to withdraw a single penny, lordship. And without any rhyme and reason, repeatedly this honorable court instructed the bank to show the reasons why the accounts has been held up.
So there is a status quo order not to alienate also.
Yes, not to alienate. We are not alienating. Or there is no court order, lordship, restraining the petitioner from withdrawing the amount from the bank. It is our money, lordship. The bank is recognizing the petitioner as the landlord. There is no dispute to that. And the bank has written a letter, lordship, to the petitioner that you submit a succession certificate and next of kin certificate will release your account.
Then
Then we submitted our succession certificate, next of kin certificate. Thereafter also, lordship, may please to peruse I have filed the additional affidavit, lordship. Lordship, may be pleased to take up the additional affidavit, page 205, lordship.
who is appearing for Bornali Das? Who appears for this one? Mamoni Devi. Respond number 3.
Nobody is appearing. No affidavit of opposition filed. Notices were duly served. Lordship, may please to take up the additional affidavit filed by me. Page 205.
No, it is not that you are not able to operate the bank account, but they are not putting a lien, they are putting a lien on that rent. And thereby not allowing you to use that amount.
They are depositing the rent in the bank account of the
But they
petitioner
are
number
not putting a
3.
lien,
But
thereby not allowing you.
No, not allowing to do. Lordship, they do not have any income except the rent. Petitioner number 2 is a widow. Petitioner number 3 is a unemployed youth, Lordship. They are starving actually, Lordship. The petitioner number 1, Nirumpa, she expired because Lordship proper treatment cannot be given due to lack of money. In spite of having 65 lakhs in my bank account.
But why the suit is not proceeding?
So it is proceeding, Lordship. It is
What
now
is the stage of the suit?
lots of miscases were filed, Lordship. Even the private respondent number 3, she closed the staircase by putting an iron gate over the staircase for going to the first floor of the bank, Lordship. So lots of
No, understood. What is the stage of the suit?
cross-examination of PW.
Wait for some time. We can't allow you.
No, Lordship,
Because if you allow you today, and then tomorrow her counterclaim is given, what will happen to the rent?
Lordship, counterclaim is not maintainable before the civil judge senior division number 1 because
Can I decide? Can I decide?
No.
So therefore,
Can
I
civil
can't
court can decide, Lordship,
So therefore, why you are not? You are such an experienced lawyer. Why you are not filing a rejection of an application for a rejection of the counterclaim?
I have already filed. I have already.
Very well.
In
The moment it
WS
is done, it is okay.
No, Lordship, please see the humanitarian. At least 50% amount I may be allowed to, or to even 20%.
How 50%?
How else petitioner will survive, Lordship? They don't have any other.
Survive, you know what to do. You should file your application out there. Anyways.
Defendant, Lordship, that is respondent number 3, delaying intentionally, Lordship, filing one and another petition on each date, Lordship.
File a rejection application. You know it.
Rejection application has been already filed.
Then why it has not been rejected? Should have been rejected.
No, there is 2-3 numbers of injunction disobedience petitions are pending, miscellaneous other. Lordship, it is what is the Lordship?
Taking into account that Mr. B.K. Sen, the learned counsel appearing on behalf of the State Bank is not present, the matter stands adjourned to be listed again on
short date
23/2026.
Which date fixed, Lordship?
23.
23, my lord, I am having a
Okay. When do you want it?
before that or after I am having a matter in the FX court.
6th of April.
Before 23rd, Lordship.
Before 23rd. 23rd is 20.
Okay. Obliged to.
What is your matter about?
And compensation. Right, because obviously they are members. Land excluded by the respondent of the sole construction of NS 120B. What they have done is
What is this adequate compensation means?
compensation.
You have received some compensation.
No, I have not received.
Then why you are saying adequate? Anyways, Mr. Borua, what is the matter about?
Now your question is that respondent number 6, they have released the amount for respondent number 6, but he is not legal possessor of the land. Respondent number 6, they have released the
My lord, as per 3D and 3G, they have done already amount which is decided by complaint land acquisition. Within the repairing agency, already we have deposited amount. Now, my lord, dispute is between this private respondent and petitioner. Maybe that is your lordship.
Has the amount been has the amount been released?
No, not yet, because that is this
Amount has not been released.
released. Then that will be given this.
Competent authority? Has the amount been released?
No,
That's one for that.
And what is the total compensation?
That's.
Huh?
That's but some other person, they producer of that, they have already received 23 lakhs. Petitioners have not received single point. Petitioners.
Who are you?
My part, I'm for respondent number 6, lordship. My part has been received, lordship. Out of 58 lakhs, lordship. We have received 19 lakhs, 61,210 rupees. We have received our part, lordship. And
Now, are they not disputing your claim?
no, lordship. No, lordship.
Where is your application? Let's see. Before them, before the DC, competent authority. Where is your application?
Page 43, I have my objection, page 43, I have.
So that you are the owner of this total 2 bighas, 2 kathas.
The ancestor property.
And that amount is total is 58 lakhs.
58 lakhs.
And out of that amount of 17 lakhs have been given.
That's not given.
Page 44. Have this land been given?
Yes, behind the that's number 6.
Huh?
That's number 6.
Okay. So there is a dispute. Mr. Yuakala, when there is a dispute in terms of 3H4, you have to refer it. Refer it. Matter over. Heard Mr. S. Islam, the Learning Council, appearing on behalf of the petitioner. Mr. Revenue N. Bodlo appears for respondent number 1. Mr. So-and-so C. Burwa appears for respondent number 2.
2 and 7.
2 and
7.
7 is there.
Subsequently.
2 and 7. Mr. J. Hendig appears for respondent number 3, 4, and 5. And Mr. So-and-so appears for respondent number 6. The petitioners herein claim that they are the original owners and pattadas of a plot of land measuring 2 bighas, 2 katha, 10 lechas covered by Dag number 61 of Patta number 279, situated at village Kisamadaha, page 43. Part 2, under Revenue Circle, Dhubri, in the district of Dhubri, Assam. In connection with LA case number 14/2016, an award bearing number 380, package number 2 have been passed in terms with section 3G1 of the National Highways Act 1956, for short the Act of 1956, awarding an amount of rupees 58,42,334. It is the case of the petitioners that the respondent number 6 is not entitled to any amount, as he is merely a trespasser.
No, his land is different. As per the revenue, his tract number is 6, patta number 57.
Mr. Counsel, see page 44. You are coming up with a different story. The application says about a different story. It is a case of the petitioner that the respondent number 6 has shown his name as a possessor in respect to the said land, but he has no possession. And an amount of rupees 17,80,092 out of rupees 58,42,334 have been allocated against his name. In terms with that, the petitioner therefore had submitted an objection before the respondent number 3. However, that same have not been taken into consideration. And it is under such circumstances the petitioner has approached this court. From a perusal, well, I've also heard Mr. So-and-so who appears on behalf of the respondent number 6 who submits that he has received an amount of rupees.
61,210.
Give it out there properly. Against the same land.
Against the tag number 57, Patta number 6.
Against DAG number
57.
67.
57.
57 of Patta number
6.
6 at village Kisamatha so and so part 2 under revenue circle Dhubri in the district of Dhubri, Assam. In view of the submission so made on behalf of the respondent number 6, it therefore appears that the amount so received by the respondent number 6 has no relation with the lands claimed by the petitioner to be their own land. Be that as it may, a dispute has arisen amongst the petitioner as well petitioners and the respondent number 6. As to the entitlement as well as apportionment of the land. At this stage, this court finds it very pertinent to take note of Section 3H4 of the Act of 1956, which stipulates that when there is a dispute, the same shall be referred to the court of the principal civil judge within whose jurisdiction the land is situated. Taking into account the above, it is therefore the opinion of this court that the disputes as regards entitlement as well as apportionment of the amount pertaining to the land claimed by the petitioner in its objection filed on 25/8/2023 before the respondent number 3 is required to be disposed of, is required to be referred to the court of the court of the learned district judge Dhubri for a decision in terms with Section 3H4 of the Act of 1956. Accordingly, the instant writ petition therefore stands disposed of, thereby directing the respondent number 3 and 4 to take effective steps to respond number 3 and 4, and more particularly the respondent number 4, who is the competent authority appointed under Section 3a of the Act of 1956, to refer the dispute to the court of the learned district judge Dhubri within a period of 15 days from the date a certified copy of the present order is served upon the respondent number 4. The writ petition accordingly stands disposed. Understood, but this I take it as respondent number 4. Because it is the Kala who can do it, not the district commissioner.
Because order leader 76 will be there.
What is your case?
The eviction order we got, just 12 months before. I think that's what 9, 8 and 9 I have represented in item number 9.
Wait, who is appearing for 5084? You are appearing for?
Right.
5084. You had submitted some representation. What is your representation?
You have to file the application. Plus, phone number 7 to 10. You have to file the affidavit because there is an order is there, 17/6 to 25.
What do you want in the representation?
Before launching, it's on the under private customer number 7 and 10. And being comes to occupier and without informing them on 18 April 23, private customer filed one WPC number 1723 of 23. Basically paying for removing of illegal occupants from the particular land, which covers an area. And followed by that order, 10/9/24, the concerned circle officer conducted one public hearing. On the public hearing, petition for lordship could not appear because this friend of time was not present at Gauhati. Subsequent thereafter, on 9/8/24, the GMC sealed the property and subsequently those seal the property. The petitioner could not vacate the scheduled land and hence paid for extension of the public hearing.
Yes, who is 5044? What is your case? What is 5044? Your case, setting aside the eviction notice? Yes. Yes, Mr. Chaudhary, why you are appearing?
Actually, their allegation that they were not heard or given notice is not correct, Milord. We have filed the affidavit, Milord. In fact, Deputy Commissioner has taken hearing of all of them. All of them were present. And
Now, what do
thereafter,
they
Milord,
want? What do they want now?
Milord,
What do they want now?
as far as my learned friend's case is concerned, he wants disposal of his representation, but there I have got nothing to say. That's why we have not filed any affidavit.
And I don't direct for disposal of your representation unnecessarily.
Yes.
Yes. That
If
is
you
the,
lordship-
that is the, if you ask for not to evict, I can pass that order, but to pass an order to dispose of the representation is a very difficult
Two
thing.
issues are there. Basically, two issues are there.
And second
One
prayer,
issue is-
sorry, ek minute, huh? Second prayer is, Milord, to modify the order passed in the other case.
Which is impossible. Yes, what is his other case?
Other case, yes. If a lordship would kindly come to our affidavit, Milord, at page 10,
Who are you? You are Brihattar
Committee.
Gauhati, Robi
Committee.
Das, Muchi, so-and-so, Unayan, Hongo.
Yeah.
Now, this is a land belong to you.
Actually, Milord, it's a government land. It is reserved for Milord graveyard and all of the Muslim community.
Okay.
And we are basically looking after the welfare of the people, Milord.
Of the Musi community.
Yes.
Okay, then. Now you allowed him to use the land to Mr. Sinha's client
If your lordship would kindly come to Annexure 6
of
the writ petition.
5044.
Yes.
Each
Order passed in Milord, WPC, page 37, the operative portion.
Ah.
This writ petition was at our instance, my lord.
Okay.
Petitioner number 1, Sangha, namely Brihattor Gauhati Ravidas Sampraday Unnayan Sangha, which is registered under the Societies Registration Act, bearing registration number so and so. The petitioner number 2 is the president of the society and present Mahant of the Musik Avastan at Gauhati. Petitioners number 3 and 4 are members of this society and they belong to Musik caste, which is recognized as a scheduled caste under the Constitution of India, Scheduled Caste Order 1950. Grievance of the petitioner is that they had been allotted composite plot of land measuring 7 biga 9 lecha, covered by Dag number so and so, in Revenue Village Sohor Koronia Part 2 under Moza Udubari. The said plot of land is used as a graveyard known as Musik Avastan for the burial of the person belonging to the said community. It is the claim of the petitioner that some unauthorized person had occupied some portion of this land without any authority and are refusing to vacate the land and thereby causing hindrance to the purpose for which the land has been allotted to the
I think this matter should go before that judge. Taking into account, I have very difficulties in accepting this order. You claim that the land
No,
belongs
pursuant
to
to-
a government.
Basically, it's a government land has been allotted to us for this purpose.
Has there been an official allotment?
Yes, yes.
Where is your allotment?
I think there was a title suit, my lord, where this fact was established.
No, where is your allotment by the government?
My lord, that allotment we have not brought on record. If necessary, we can do that.
Show me one piece of paper would do.
Please come to page 20, my lord. I think that's the Sita. Page 20, my lord. It starts at page 18. And at page 20 on the right hand side, my lord, remark column. Mondal remark, Musik Avastan, Musik Avastan.
So it is used as Musik Avastan. So therefore, at your instance, direction is being passed, directing the state to evict unauthorized occupants on
Yes.
respect to government land. How is it possible?
No, my lord, no, once the allotment has been given.
Where is the allotment? That is my questioning. This is not
You
an
can look at
allotment.
it, my lord.
No, it is not an allotment. It is a use.
Huh.
It is an use being made. Therefore, it is said that Mondal has remarked.
No, eventually it is the government authority who will remove them. Not,
Understood,
not
but
at
why a writ has to be issued to evict for your benefit? Because as of now, you have no right over the land.
Technically, yes, my lord.
Better off, I think, goes to that
Same
judge.
way. Have a day.
And they were not parties to that proceedings. But at your instance, government direction is given that the government will evict them.
No, there was a full-scale hearing, my lord. They have all attended also.
Understood, but what was the necessity? Because it is, as of now, it is not your land also. You are using it. It's a different thing.
No, my lord, it is something like the Cotton College. This entire land in Panbazar. It's a government land. The remark could be Cotton College. It happens in any government office, my lord, land. The land is a government land, but it is used for so-and-so purpose. That does not mean, my lord, somebody else will come and occupy that land.
Cotton College
Yes,
will
my
be,
lord.
it
We are
will be
not
allocated.
landholder, settlement holder within
No,
the
no, no,
meaning
no,
of-
no. When, just for example, I'm saying, I won't say about Cotton College, but
Yeah.
High Court. I say
High
about
Court.
High
High Court land.
The land is allocated to the Gauhati High Court.
But
Unless you
normally-
don't allocate it.
Normally, I find, my lord, in government lands, whenever any institution of any public importance or comes up, and the revenue record always says Sarkari.
It will be said that it is reserved for them.
Sarkari, the class of land is Sarkari, but reserved for so and so.
And there has to be an order by the government, not by Mondal.
So, my lord, I think to the extent that this is a Musik Avastan, it must have been done by the government. Well, I don't think Mondal or cycle officer
So
can.
there
pass
has
that
to be
order.
something not on the basis of a Mondal's report. Anyways, better off it goes there. This court have heard the learned counsels appearing on behalf of the parties. And one of the prayers made in WPC number 5084/2024 is seeking certain modification to the order passed by the learned coordinate bench dated 10/6/2024 in WPC number 1723/2023. How far the said prayer can be maintainable? Full stop. Taking into account the said, it is the opinion of the court that the said aspect be placed before the learned coordinate bench who had passed the order dated 10/6/2024 in WPC number 1723/2023. List according. The registry shall do the needful. The registry shall be listed before the learned coordinate bench. তার নাম তো লিখে দিব, হ্যাঁ, সুমিত্র সৈকে দে। On or before, on 23/2026, interim order passed earlier in both the writ petitions. Both? You are also having an interim order? Sure.
No, tomorrow is, no, I think this, no, tomorrow.
Passed in both the writ petitions stands extended till the next. Yes.
This is the pilot, I have a license, my daughter. I had to in 2019, when my license ran expired, I applied for renewal, my lord. And thereafter it was kept pending. And thereafter, my lord, I filed a reminder and I filed a regulations. Thereafter, my lord, an order has been passed whereby my license has been revoked on the ground. 5 cases has been pending against me. Against that order, my lord, I have filed an appeal. And the appeal order was passed in the appeal manner that 5 cases is pending against me out of 5 into my lord, final report has been submitted and another 3 my lord was transferred to I have challenged that order. The appeal order passed in the earlier it is page number 56 my lord, annex 5. This is the first order, my lord.
But there are 5 cases pending against you. Is there any doubt on that?
Out of 5, my lord, so far the 3 cases is concerned. 2, my lord, final report has been submitted. So 2 is 1, my lord, out of other 3, my lord. On those 3 cases, I have filed a criminal petition for this honorable court, and this honorable court stayed, my lord. And thereafter, when those cases were stayed, those cases were again transferred to PIEO, my lord. And this case, the case is
So it's still pending.
so far the cases is concerned, my lord. Those cases are regarding economic offences, GST, regarding GST, my lord.
Huh?
GST, my lord. So far the, my lord, for revocation of gun license, my lord, the ingredients which have been prescribed in 17, my lord, called, my lord, public peace and, my lord, may I refer, my lord, section 17 of, my lord, Arms Act, my lord. And that apart, my lord, I've applied for renewal in 2019. Cases were registered in 2022, my lord.
But till then, it was not registered. Your renewal has not been granted. So if the renewal was not granted then, but after that the case has been registered, then
State, my lord, and so far the, my lord, section.
why you have not filed your reply to the affidavit? You have filed? When? It is not here. An affidavit in opposition filed by the respondent number 4. When did you file? And these cases which are there, this is under 180, 420,
My lord, I have a
which have been transferred to the, this is nothing to do with GST. This These are the under 207, 468, forgery, 471, 420.
These are, my lord, economic offenses. Therefore, it's honorable to state this order, this proceeding of this case is final. I have annexed the stay order, my lord.
Where?
From 100.
No, it is in state, but it has not been quashed. No,
So section 17 is.
once it is quashed, then I think you have a case. Otherwise, no case. Then also the other aspects comes in. Anyways. Get those things quashed, then only you have a case. As of now, there is no good ground for allowing your petition. 7.
A licensing authority may by order in writing suspend a license for such period as it being fit or revoke a license. A, if the licensing authority is satisfied to the holder of the license prohibited by this act or by any other law for the time being in force from acquiring, having in his possession or getting any arms or ammunitions or is of the unsound mind or is for any reasons unfit for a license under this act. Or B, if the licensing authority deem it necessary.
You had a license. We are not on the question of revoking, renewal.
So far the matter, the Indian order is concerned, that order my license.
Have they revoked? They have revoked the license. So you therefore say that all these conditions which is there under 17.3 is not there.
Regarding 70, there is no such square matter.
So it has to be, your therefore cases, it is not a case coming under 17.3.
It would be 6 months, first order, my lord. Last paragraph.
Page?
I see 53. So I say Pallab Gopal Jha, IAS, Mr. Kamal Metogan is satisfied with mention observations to have a revoke the arms license of the petitioner.
Page 53.
56. Last paragraph.
Okay, against that you have filed an appeal.
The appeal to the order was upheld. After I come to court, but it's mentioned.
But in the affidavit which has been filed by them, they have only mentioned about these 5 cases, of which they say 2 cases FR has been given at paragraph number 5. As regards the 3, they are before the BIO.
5 cases they have mentioned.
And where is your reply? Anyways, we do one thing. They have not specifically mentioned under what provision they have done so, taking into account that the revocation can only happen if it is not at your volition under 7.4, it has to be under 7.3. Under what, because this affidavit is not clear on that aspect. Let us get an affidavit on that aspect. Petitioner herein is aggrieved by the revocation of the petitioner's arm license by the order dated 19/1/2023 by the District Magistrate, Kamrup Metropolitan District, as well as the order dated 24/7/2024, by which the appeal has also been dismissed. It is noticed that pursuant to the filing of the instant writ petition, notice was issued, whereupon an affidavit in opposition is filed by the respondent number 4. At paragraph number 4 of the said affidavit, reference is given to 5 cases which were pending against the petitioners. At paragraph number 5 of the said affidavit in opposition, it is mentioned that out of the 5, 2 cases have, in 2 cases, the final report have already been submitted. And in respect to 3 cases, the same have been referred to the BIEO. The learned counsel appearing on behalf of the petitioner submitted that in respect to the 2 cases where FR has been already submitted, there is nothing. The cases are closed. However, as regards the 3 cases, the petitioner have assailed the same by filing quashing applications before this court, wherein orders have been passed, thereby staying the further investigation. Be that as it may, it is the submission of the learned counsel appearing on behalf of the petitioner that the license, an arms license in terms with the Arms Act 1959 can be revoked when circumstances exist as mentioned in section 17(3) of the Arms Act of the Act of 1959. Referring to the affidavit in opposition, the learned counsel submitted that there is no mention as to how any of the circumstances mentioned in section 17(3) of the Act of 1959 is applicable. Further to that, the learned counsel submitted that in respect to the cases which have been stayed by this court, those offences are offences pertaining to certain violation, certain alleged violation of the GST provisions. GST provisions. And therefore, the same under no circumstances can be said to have any impact on the security of the state. The learned counsel therefore submitted that merely because cases are pending cannot be a ground unless the circumstances exist as mentioned in section 17(3) of the Act of 1959. This court have also perused the impugn orders as well as the affidavit in opposition filed by the respondent number 4. There is no mention in those in the impugn orders. It is relevant to mention that in the impugn orders as well as also in the affidavit so filed, the license of the petitioner, armed license of the petitioner have been revoked on the ground that there was 5 cases pending, criminal cases pending against the petitioner. But there is nothing mentioned as to whether any of the 5 cases which are pending have any relation to the circumstances mentioned in section 17(3) of the Act of 1959. Under such circumstances, this court fixes this matter again on 30/3/2026. The respondent number 4 shall file an affidavit, shall file an additional affidavit as to whether any of the conditions mentioned in section 17(3) of the Act of 1959 exist for revoking the license of the petitioner. The affidavit be filed on or before 25th of March 2026. I think by this way you can get it. Refusal to pay interest on the PPF account which was open in the name of Why no affidavit filed?
Okay, the receiving instruction, Lordship, I can file within 2 weeks.
What instructions?
So instruction, Lordship, that provisions of that act was amended with effect from 13/5/2005. Lordship, I flag marked that amended provision. So in view of that, only the individual could have opened the PPF account, Lordship. So HUF cannot open the account, Lordship. Itself was wrong. That's why
As per the amendment, only individuals can invest in various small savings. Jurisdictional persons, including HUF so and so, will henceforth not be eligible to invest in any of the small savings schemes. This happened in 2005. When did you invest?
2005. Six.
After that?
After that, Lordship. That's why we agreed to return only the principal amount.
It was opened by the postal department. And continuous for 15 years, they have received my amount.
No. Then give him whatever it is, the normal one. PPF, you give more interest. But you have withheld that amount. But you're not giving the normal banking rate. You see, when this circular was there, did you inform him that look here, first you have opened it.
There is a fault on our office. Because
Then
what
you-
happened
First you
sometimes-
have opened it. And secondly, why did you continue all this while?
Because sometimes the accounts are opened through the agents. Earlier period of time, there was private agents. They to fulfill their targets, it bring anything from the
Understood. For how many years this has happened?
I have deposited 15 years.
maturity is
The
23.
when they wanted the refund, then they said that you are not entitled for the interest. I have opened the account to get
Basic.
interest.
I think the basic interest, at least some interest has to be given 3%, 5%, 6%, something.
Let me
May
take
not be the
inspection
7.1% or 8% which is given in the PPF.
PPF.
No. But something as per the savings bank account also, you can give on a recurring deposit, which you.
It was wrong from the very beginning, Lordship. Something was wrong from the very beginning.
Understood. The wrong means you should not have accepted it. Anyway,
Sir, there is a wrong fault on our part also, Lordship.
can't help you. That's the law. You knew it. You should know it also. Not knowing the law is a refrain because you see, this is not only a circular based on a circular. So what? Go and ask him on a personal liberty, on a personal form, whoever have opened it.
Accepted the amount 15
No,
years.
you see that it has been amended. The section 4 of section 3 of the AIA was amended.
And they have not communicated us during the 15 years. That this, because they themselves have opened my account in their branch.
Can't help it.
Kindly page number,
Who has opened the account?
postal department. Page number 24, annexure B.
Anyway, you file your affidavit. He is not entitled to it. You file your affidavit and on the basis of the affidavit, we'll dismiss it on the next day. Mode of operations, yeah. Heard Mr. A. Kabra, the learned counsel appearing on behalf of the petitioner, and Mr. B. Chakraborty, who appears on behalf of the respondents. The petitioner has approached this court challenging, seeking a direction upon the respondent authorities to pay interest on the deposits so made in the Public Provident Fund Scheme. By the petitioner. It is relevant to take note of that the petitioner is a Hindu undivided family. Mr. B. Chakraborty, the learned counsel appearing on behalf of the respondent, submits that with effect from
13/5.
13/5/2005, comma, Hindu undivided family or any association of persons could not have opened any account in the under the Public Provident Fund Act 1968 in view of the amendment to the provisions of the said act. He further submitted that a circular was also issued in that regard on 16/5/2005, informing all heads of the circles of regions, additional Director General APS New Delhi. It is the opinion of this court that the said aspect be brought on record by filing an affidavit. List this matter again on 8th of May 2026. Affidavit be filed on or before 27th of April 2026. Liberty given to the petitioner to file any reply. Oh, very good.
Continuing list of number 18, can it this matter be fixed at 2 p.m.?
What matter is this?
Yes. Patta has been cancelled, Lordship.
By
By authority in 1979, Lordship.
non-renewal case.
Lordship.
Then why is it being challenged now?
They have approached the Revenue Board also. Revenue Board also dismissed their cases, Lordship. In 2014,
Revenue
Lordship.
Board dismissed.
Lordship. In Lordship.
So are they challenging the Revenue Board's order?
In page, can you see the page 40, Lordship?
May please.
Impugn order passed by the Revenue Board and set aside the said order dated so and so, cancelling and annulling so and so. Violation of principle. Where the records, affidavits filed?
Affidavits filed, Lordship.
So taking into account that the pleadings are complete, comma, this court admits the instant with petition. List the matter for hearing in the month of June 2026.
My lord, matter pertains to cancellation of Patta, Lordship. Cancellation of Patta, Lordship. Cancellation of Patta, Lordship. Matter pertains to cancellation of Patta, Lordship. The petitioner, Lordship, herein, Lordship, purchased a plot of land, Lordship, in the year 2008, Lordship. Thereafter, Lordship, the land was mutated in his name, Lordship. And, Lordship, the Assistant Revenue Officer, Lordship, Karbi Anglong Autonomous Council has, Lordship, cancelled the Patta issued in favor of the petitioner, Lordship, based on objection raised by a society, Lordship. Thereafter, Lordship, petitioner approached before the Board of Revenue, Lordship, and the Board of Revenue has set aside the cancellation order, Lordship, and directed to restore the Patta in the name of the petitioner, Lordship. Thereafter, Lordship, the opposite party has approached before the Honorable Gauhati High Court, and the Honorable High Court has reaffirmed the order passed by the Revenue Board, Lordship. Thereafter, Lordship, petitioner submitted representation before the authorities, Lordship. And finally, Lordship, the Assistant Revenue Officer, Lordship, passed the impugn order, Lordship.
can be disposed of, my lord, directing to take a decision within a period of 6 weeks, my lord, as per rule 26, my lord, regarding confirmation or cancellation of Patta, my lord. Your lordship has already passed the order on page 28, my lord. Paragraph 4, my lord. Lordship's order is there. So,
So,
my lord, as per my lord,
so,
rule
so
26,
therefore,
for confirmation
no,
or
no,
for
no.
cancellation of
No,
Patta,
Mr. Sutia, I think the fact that this court has held, you have the power to cancel.
my lord,
It presupposes that he has the patta.
my lord, my lord,
So we give a declaration that he has a patta.
my lord, my
And
lord,
therefore,
my lord,
once he has the patta,
my lord,
you can take any action which is given
lord,
there.
my
But you
lord,
have
my
to
lord,
issue the
my
patta,
lord, my lord, my lord,
or
as,
it will be deemed that there is a patta.
my lord, regarding the Patta, my lord, I have the records, my lord. Record reveals that originally, we have stated in your affidavit, originally the land belongs to one Kamalapati Sharma. Then his name was recorded there without anything is there. His name was recorded there. Then the land, that particular mandir is there. They claim that there is a mandir. So Patta was issued in the 2010 in the name of the Patta. So he approached the, my lord, Board of Revenue. Board of Revenue passed the order regarding cancellation of Patta in his name, my lord. That is no jurisdiction of assistant revenue officer. But the fact remains is that transfer of mutation of the land in the name of the petitioner, there is nothing in the, my lord, SITA, my lord, settlement record. And regarding allotment of land,
Then if there was nothing, then why did you cancel?
my lord, assistant revenue officer cancelled it, my
So
lord.
understood.
My lord.
When you are saying that this decision is to be taken,
Now
so we
decision
do
is to
one
be
thing.
taken by the
But
executive
we do
member
one
in
thing.
charge.
We don't dispose it off.
Oh, my lord.
We direct the revenue officer,
My lord, executive
the
member in
executive
charge.
of member revenue,
My lord,
to take a decision
My lord.
as per Rule 26,
my lord,
and thereupon place it before
my
the
lord, my
court.
lord, my lord,
My lord, as
Didn't
per the
speak with-
revenue board order, lordship, there is clear direction, lordship.
lord, I
to
have the
restore
records, my lord.
petitioner in the name of the petitioner.
Lordship,
Page 23 for a
record
comment,
is
lordship.
with me.
No, no,
Page 23,
I made it very clear out here
My lord.
that there is, I'm not, the power to cancel is only with the revenue of, executive member, revenue.
My lord.
And it was done by the assistant, some
Revenue officer.
revenue
Assistant
officer who
revenue
had no
officer.
jurisdiction.
It should have been executive.
So therefore,
My lord.
I gave a liberty. It is only the commissioner who can do so. However, it has been done by so and so. So under such circumstances, this court has upheld the board of revenue's order only to that extent.
Well.
So let them decide on this 26 as per 26 and they do whatever they feel like.
My lord.
And so, and we will say that the moment they issue a notice for cancellation,
My lord.
it presupposes that you have a patta.
My lord.
My lord. Yes, my lord.
My lord.
But revenue board's direction is very clear, lordship. It is directed to restore the patta in favor of the petitioner, lordship. Page 23, lordship.
This is being given by the Board of Revenue.
Yes, my lord. Board of Revenue, lordship.
So I am not
opposite
sitting in contempt over that.
No, my lord, thereafter the opposite party approached before the Honorable High Court.
Understood. But
Yes,
why?
my
What did I say?
lord.
I said, okay, I'm not interfering with it.
My lord.
And said that it is the power is to be exercised by the revenue officer.
My lord.
So let the revenue officer decide.
Decide.
My lord. My lord.
And revenue board order is also there, lordship.
Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. And Mr. J. Sutia, the learned counsel, who appears on behalf of the Karbi Anglong Autonomous Council. The petitioner herein is aggrieved by the actions on the part of the respondent authorities in not complying with the directions passed by the learned Board of Revenue, dated 7/4/2014. In case number 78 RA brackets KRB bracket close oblique 2010, whereby the Learned Board of Revenue directed for restoring the Patta
Yes, sir.
in favor of the petitioner. Full stop. This court further finds it very pertinent to take note of that in the order dated 9/1/2024 passed in WPC number 3/888/2014, this court did not interfere with the order passed by the Learned Board of Revenue, but at the same time made certain observations at paragraph number 4 of the said judgment. The said paragraph, being relevant, is reproduced hereinunder. Page 28. From a perusal of the above quoted paragraph, it is apparent that this court interfered with, this court opined that the Assistant Revenue Officer, Phuloni Revenue Circle, did not have the jurisdiction in terms with Rule 26 of the in terms with Regulation 26 of the Assam Land and Regulation, no, Rule 26
of the settlement rules framed under the Assam Land and Revenue
Rule
Regulation.
26 of the settlement rules framed under the Assam Land and Revenue Regulation 1886. And further opined that such power can only be exercised by the settlement officer, which insofar as it applies to the Karbi Anglong Autonomous Council would be the executive member revenue. First, taking into account the above, Mr. J. Sutia, the Learned Counsel appearing on behalf of the petitioner, Karbi Anglong Autonomous Council, submitted that steps are being taken for the purpose of taking a decision in terms with Rule 26 of the settlement rules in respect to the case of the petitioner by the executive member revenue.
Fine.
And the same would be placed before this court. Placed before. Taking into account the above, list this matter again on 11th of May 2026. The executive member revenue of the Karbi Anglong Autonomous Council shall place before this court its decision as regards to the action taken as to whether any orders have been passed in pursuance in terms with Rule 26 of the settlement rules, insofar as the present proceedings are concerned, insofar as the Patta of the petitioner is concerned. What is this?
My lord, here, petitioners are aggrieved by the inaction of the respondent side, granting in solatium 30% and 12% on land acquisition compensation. So kindly find this honorable court has passed an order dated 23/5/2017. It is page 24. This honorable court has directed the respondent to pay 30% solatium and 12% interest.
Huh?
30% solatium and 12% interest on the compensation granted for land acquisition.
Hmm.
And in compliance with this order of this honorable court, it is annexed to. They have complied with it is in partly, and these petitioners are being deprived from being paid this compensation, solatium.
So you are not there.
Yes. Page 44. Two lists are here annexed. Number one list, it is
the persons to whom this solatium and interest has been paid, and annexed to internal to.
So
it
you
is-
come under those people at page 44, 45.
Yes, my lord.
My lord, I have some instruction, Lordship, due permission I'm placing. Here, because your Lordship, Tarsem Singh versus Union of India, earlier it was provision was not there. Tarsem Singh on her case, Honorable Appeals Court has given. But that is under review, my lord. We are putting on review. That is why though we have sent their proposal for event, but due to this pending before the Honorable Appeals Court, this not, I think this has not been sanctioned so far. Let's say till decision comes, my lord. It may be kept in abeyance.
There's a Supreme Court judgment wherein it says that filing of a review does not mean stay to the judgment.
That is why, my lord, I have to now, that is
How
why
does it be
today,
right? How do you delay this?
today, my lord, that is why after receiving, today I pay for some time so that this result, whatever it comes up. Whatever lordship passes order, will you please to pass an order, just. But what is the outcome of this, I could not put because I was out of the morning. I saw this, I said, some time may be given at least.
Where is the judgment? That
My
judgment
lord-
is the case of Allahabad Bar Association or something, I suppose. Wherein it says that, oh no, there is another judgment. Wherein it categorically says merely filing a review
My lord.
would not amount to stay.
No.
The law would be applicable.
Yes,
And the law laid down in Tarsem Singh would be applicable. Have you found out that judgment?
I have to charge, my lord. I have to discharge on this.
How do I help you?
Well, otherwise, fund was sanctioned and that fund, kindly find, fund was sanctioned and that fund was laying in the Axis Bank Bongaigaon from 18 to 2021. The respondent number 3, it is supposed to the owners to disburse this amount to the petitioners. He had not disbursed this amount and that amount was withdrawn by the National Highway Authority of India in the year of 2021. Kindly find. I have stated,
Where is your name at page 44?
my lord. Petitioner number 1. Petitioner number 1, it
Hey,
is 7.
do one thing.
It is 7.
We
Serial
do one
number
thing.
7.
You bring me that judgment, you'll get it. Get that order. Otherwise,
May I also put this on record?
not necessary. This is not Mr. Borwa,
That's-
this is the second time you are coming up with this type of matter. The last time also, around 2 years back also, I got something same.
No,
Now you have filed this diary number is of 2025. We are in 2026 now. And it is no longer, if it, you must have kept it defective. Otherwise, it cannot be a diary number for all this trial.
And yeah, I'll also find out what is this
This
outcome.
type of instructions have no value. Full stop.
Otherwise,
I'm
my
not
lord,
going to consider this type
8
of instructions.
years has been elapsed from the order passed by this honorable
Yes, sir.
court.
It is seen that though notice have been issued as far back as on June 2025, the respondent authorities have not filed their affidavit in opposition. Full stop. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submitted that the petitioners are part of the petition, the petitioners
Are the members.
are amongst the group of persons who were parties in WPC number 511/2012. And various persons have been paid the 30% solatium along with 12% interest. But the respondent authorities, for reasons best known, have withheld the said amount to be paid to the petitioner, although the respondents were bound to do so in terms with the order dated 23/5/2017 in WPC number 511/2012. The learned counsel also, for the petitioner also referred to the judgment of the Supreme Court in the case of Tarsem Singh versus Union of India, reported in
Plus. The civil appeal was 7 years.
versus Union of India.
Yes, ma'am. Bill appeal number was, I think, 7064, 2019.
No, your thing has been dismissed.
No, that is why, Lordship today, as I there is a year put on this one for review, I think. This in detail also they have not come to me. That is why it was dismissed. That is why it was for review, I think it was filed.
You
And I
see, the
clarified this
Tarsem
one,
Singh judgment
my lord.
was Union of India versus Tarsem Singh, reported in 2019 9 SCC 304. The learned counsel further submitted that the Union of India thereupon had filed another application before the Supreme Court, which was registered as miscellaneous application number 1773/2021, seeking clarification regarding the judgment dated 19/9/2019 passed in the case of Union of India versus Tarsem Singh Supra, to the extent that the aforesaid judgment be applied prospectively. The learned counsel submitted that the Supreme Court, by an order dated 4th of February 2025, in the case of Union of India and another versus Tarsem Singh and others reported in 2025 SCC Online SC 235, categorically observed that the principles established in Tarsem Singh in the case of Union of India versus Tarsem Singh, reported in 2019 9 SCC so and so, regarding the beneficial nature of granting solatium and interest, while emphasizing the need to avoid creating unjust classification, lacks intelligible differentia. And accordingly, the said application was dismissed. The learned counsel therefore submits that under no circumstances, therefore, the respondents herein can continue to deprive the petitioners of the benefit of solatium as well as the interest accrued thereon. Interest. The solatium at 30% and interest at 12%, along with the interest there accrued thereupon. Mr. Sibulwai, appearing on behalf of the so-and-so, submits that one further opportunity may be granted. Taking into account the above, list this matter again on 16th of March 23rd of March 2026 for final disposal.
My lord.
You get that?
My
What I asked you?
Yes, I'll find out. Obliged.
What you are asking, that is also gone. That was the review which was filed. 1 year back, when you had when the matter came before me, you said that you have filed a year that it should be applied prospectively and not retrospectively and all. That is also that application. That is the order.
Remembering each other.
Ah.
Obligement.
What is this?
Well, your lordship has passed an order, but it has gone in WPC, in writ petition.
What?
That your lordship will get an order on 21/1/26. It should have been in IA.
Revenue and settlement authorities to take away for preventing unauthorized construction over the plot of land or covered.
This has been violated. They are constructing it.
Who?
So these persons, this Gauhati, these constructing will file a contempt petition, madam.
What is your
Alternatively,
case?
may I suggest, my lord, because this land was allotted to the petitioner on, my lord, 11 to 25, page 24. And thereafter, after all these formalities and all, then it was cancelled without hearing the petition. So what I, subject to what your lordship may say.
This is by Dima Hasao. Who
Demas,
appears for Dima Hasao?
Demas.
You are the beneficiary.
No.
Are you the beneficiary of these actions? For whom are you appearing? Who is he? Private respondent?
Secretary David Long, private respondent.
Who appears for Dima Hasao? 1, 2, and 3 has filed an affidavit.
Hello, what I was thinking, subject to your lordship may say, since it was cancelled without hearing the petitioner, I think, my lord, if your lordship sends back the matter to hear the petitioner and other affected parties, take a decision and to maintain status quo till then, my lord. Some of the facts are not, the affidavit filed by the NCL's Autonomous Council, it says different, and I'll have to take instructions on that. But the matter can be sorted out by remanding the matter to the authorities.
Who is appearing for Dima Hasao?
Demas of presently, I was told, man, that he's on legs.
Has their names been shown?
D. Thousand's name is there. He got, well, married recently, my lord.
Huh?
Mr. Thousand got married recently. So I think he's coming next week. That's what the instruction is to me.
Okay, then we adjourn it. Okay. Taking into account that none has appeared on behalf of the Dima Hasao Autonomous Council, the matter stands adjourned to be listed again on 25th of March 2026.
And the interim order dated will continue at
What interim order?
that not to be constructed.
How can there be an interim order passed
No,
by
in
this court?
in
No,
this case, man,
no. This type of order I am not going to continue. Sorry.
that order is already there.
Absolutely no. This is a civil dispute. You are appealing for whom? Dima Hasao? Oh, fantastic. We dispose it of.
Yes,
You see,
to hear both the parties.
you have done so on the basis of a complaint given by respondent number 3.
My lord.
Okay. Did you hear him? No. That is apparent from your affidavit.
My lord.
So we do one thing, we set aside that. We take a decision by giving him a hearing. Matter over. But no interim order of these types.
Interim order was passed.
You are lucky
for
enough.
maintaining
The
status
very
quo.
kind judges you are getting.
Yeah.
Heard Mr. B.D. Das, the learned counsel, senior counsel appearing on behalf of the petitioner, assisted by so-and-so appearing on behalf of the petitioner. Mr.
I'm D. Kolita, my lord, on behalf of Mr. D. Thorsen.
Mr. D. Kolita appears on behalf of the respondent numbers 1, 2, and 3. Mr. So-and-so appears for respondent number 4. Any more? Only till respondent number 4. Are there any other parties? Yes, yes. You have not served a copy to him.
For the trust.
You have not served.
I can give a copy. We can give it now.
No. Take it.
Notice.
Yes.
Notice also there. You can.
The instant writ petition has been filed on behalf, filed by the petitioner, challenging the order dated 22/2025, by which the additional secretary and revenue officer, Dima Hassan Autonomous Council, have cancelled the order dated 11/2/2025, whereby a plot of land was allotted to the petitioner on payment of the settlement fee of rupees 20,000. It is also mentioned in the impugn order dated 22/2025 that the reallotment shall be done upon the dispute being settled amicably between the parties in the Dima Hassan Autonomous Council Court. This court have duly taken note of, Mr. B.D. Das, the learned senior counsel appearing on behalf of the petitioner, submitted that this order, the impugn order, was passed behind the back of the petitioner on the basis of certain complaint filed by the secretary of the respondent number 4. That too without an idea. Under such circumstances, he submitted that as on the basis of the order dated 11/2/2025 and the deposit of the amount of 20,000 by the petitioner, a right had been conferred upon the petitioner. Such actions of cancelling the allotment entails civil consequences. The learned senior counsel therefore submitted that this is a fit case wherein the impugn order is required to be interfered with on the ground of violation of the principles of natural justice. This court have duly taken note of that pursuant to the filing of the instant writ petition, an affidavit has been filed by the respondent number 3, 1, 2, and 3. In the said affidavit, it is seen in the said affidavit, more particularly at paragraph number 7, it is seen that a complaint was filed on 13/2/2025 by one Kennedy Ingi, son of late David Long Engi before the respondent number 3 against land encroachment by the petitioner. And on the basis of the said complaint, the order of allotment dated 11/2/2025 issued in favor of the petitioner was cancelled. Full stop. The statements made in the affidavit apparently makes it clear that the said action was taken. The impugn order was passed behind the back of the petitioner without affording any opportunity to the petitioner. Considering the above, it is the opinion of the court that the impugn order dated 22/2025 cannot be permitted to continue, cannot be sustained in law. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. Number 1, the impugn order dated 22/2025 passed by the respondent number 3 is set aside and quashed. Number 2, this court have not decided the rights of the parties in the instant proceedings. And the impugn order have only been set aside as it is in violation to the principles of natural justice. Under such circumstances, the official respondents, that is the respondent numbers 1, 2, and 3, shall be at liberty to take such actions in respect to the order of allotment dated 11/2/2025 made in favor of the petitioner by following the principles of natural justice. According to the petitions, no cost. I stands closed. Because I lekho here. I call lekho ka. The instant application, so taking into account that the interlocutory the main writ petition stands disposed of, nothing further remains in the instant proceedings, for which the same stands closed. Interim order stands vacated. Yes, what is this?
May I please, your lordship? Your lordship, the impugned order, lordship, which I have challenged, that is at page number 43. One particular plot of land was.
Your lordship has interim order. I am not pressing it, man. I am not pressing it.
No, that is why I'm not saying interim order in the IA. In the main writ petition,
petition.
interim order stands
For
vacated.
that,
That I know what to do. Yes, what is this?
Page number 43, lordship.
What is
Your
it?
lordship, one particular land measuring 2 kata 5 klesa was acquired. Award of rupees 62,85,484 was passed. I have submitted one objection regarding the apportionment of the amount.
Yes, what is it? You have you are the owner of the land.
Yes.
And you have not received the compensation.
Lordship, the compensation award is still pending, lordship, as because lordship several cases are going on. Here, lordship, what has happened, lordship, regarding the apportionment of the amount, I have submitted one objection. But lordship, without referring that dispute to the civil court, Kala has passed the order at page number 43. That is without jurisdiction and clear violation of section.
What order is passed?
Page 43, order
The
dated
compensation
25.
amount has been sanctioned against the acquired land.
Yes, lordship.
On the date of hearing, the Kala had again proceeded to the site and found that the objectors remaining absent, although so and so and other area were also present in the site stated area and so acquiring in Iman, they have constructed dwelling house. In view of the above, considering all aspects, Kala decided that the land value of this award dated is kept pending due to title case between so-and-so, bearing number so-and-so, and the Jirat value is hereby allowed to be recorded to the recorded demand as per their share as per year. Now, what do you want?
Lordship, that share is, Lordship, that table is there, Lordship, above. Petitioner is there at number 3. Hakim Ali. And number 2. Number 1 is the respondent number 7 and 8, and number 3 is the respondent number 9. My lord, so far as section 3H4 of the National Highway Act 1956, subsection
Has the
4.
amount been released?
No.
So, why do you keep this? This should has to be decided under 3H4.
Yes,
Lordship.
We direct them to
Yes,
refer.
Lordship. That is correct.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers. Union. Ms. Arbora appears on behalf of the respondent number 1, 1 and 6. No, 1 and 3.
I thought 5, 6.
Revenue, PWD B. Chaudhary, respondent number 4, revenue, so-and-so. Naam sab bhora dibo. Okay, who appears for 8 and 9? 8 you are and 9. Give your names, huh? The present petition has been filed by the petitioner being aggrieved by the order dated 25/10/2024 passed by whom? By the competent authority, passed by the respondent number 6, whereby instead of referring the dispute to the court of the principal civil judge, the respondent number 6, the respondent number 6 have by the impugned order have withheld the disbursement of the land value of the land and further directed that the Jirat value be paid to the respondent number 8. At the outset, it is pertinent to take note of that pursuant to the order dated 25/10/2024, no amount have been disbursed. This court duly takes note of from the materials on record that in respect to the plot of land which have been acquired measuring 2 kathas covered in dark number 155 of Patta number,
Patta number 56, my lord.
huh?
Number 56.
56
29. Yes, correct.
of village
Of village Fulkumari.
huh?
Fulkumari. Moja Gauripur.
Dark number 155 of Patta number so and so of village Fulkumari under Moja
Gauripur.
Gauripur in the district of
Dhubri.
Dhubri. You have got that amount. Jirat amount. Itu at the outset itu pusai দিব. Was acquired in connection with LA case number 1/2020-21 for the National Highway Authority, NHIDCL or NHI? in favor of the respondent number 3, no?
They have made NHI part. Now it is after NHI DCL.
Is the NHIDCL a party? No. In favor of the NHIDCL. It is seen that in pursuance to such acquisition in respect to the said plot of land, the NHIDCL have already deposited the compensation as is required under Section 3H1 of the National Highways Act 1956. Disputes have arisen amongst the petitioner and the respondent numbers 8 and 9 as regards the entitlement of the amount and or apportionment. Taking into account that such disputes cannot be decided in terms by the respondent number 6 in terms with Section 3H3 of the Act of 1956.
It is poor, my lord.
I know that. What did I say? It cannot be decided by the respondent number 6 in terms with Section 3H3. The same has to be referred in terms with Section 3H4 to the court of the principal civil judge within whose jurisdiction the land have been acquired. It is seen that by the impugn order dated 25/10/2024, the respondent number 6, instead of making the reference to the principal civil judge within whose jurisdiction the land is situated, land has been acquired, had decided to withhold the said amount till the disposal of title suit number 81/2024. And further directed that certain amounts be paid to the respondent number 8 as he was found to be in possession.
Respondent number 8 as well as the petitioner. As well as the petitioner.
Name of the possessor is Hamidur Rahman.
The table says that Lordship Hakim Ali, certain amount.
Have you got any amount? Obviously, it is not there. Name of the possessor is Hamidur Rahman. Easy. Taking into account the above, it is the opinion of this court that the respondent number 6 ought to have made the reference to the court of the principal civil judge. That would be the court of the learned district judge Dhubri, to decide as regards the entitlement of the entitlement and or the apportionment of the amount as per law. This court further takes note of that certain amounts of money have already been paid to the respondent, disbursed to the respondent number 8. In the meantime, on the basis that the respondent number 8 is in possession and he is the owner of the jirat, it is the opinion of this court that these aspects, these disputed questions, is required to be decided by the court of the learned district judge, Hubli, in the present case. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The order dated 25/10/2024 passed by the respondent number 6, which is impugned in the instant proceedings, is interfered with. Number 2. The respondent number 6 is directed upon service of a certified copy of the present order to make a reference within 15 days therefrom to the court of the learned district judge Dhubri to decide on the question of entitlement and or apportionment of the amount of compensation in respect to the land admeasuring two kothas covered by DAG number 155 of Patta number so and so amongst the respondent number amongst the petitioner and the respondent number 8 and 9. With the above, the repetition stands dismissed.
Hello.
Yes, what is this?
Receive the instruction that the scheme has been closed. The scheme has been closed. COVID-19.
When did you close it? When did you close it?
18th April 2022. The second page it is there.
And when did he die?
I died in 2020, my lord.
Then how does it affect?
For Lordship, kindly see Lordship.
Kindly see this, this closure of the scheme, the reason.
Lordship.
In view of the gradual decline of the COVID-19 pandemic in the country in general and in the state in particular, and in view of the decreasing number of cases and resultant nil fatalities due to air, it has been decided to close the scheme so and so. That application form in the portal so and so has to be closed. Therefore, the reason for closure would only be operative after 18th of April.
Lordship.
How does it have any relevance?
Lordship, kindly see the order sheet. Lordship, this was
When did he die?
On
I
my lord,
request you to honor to kindly
68,
take necessary
2020.
action to sanction the amount of it. Then, copies of the year, the year, it's a year. Request you. Sixteenth August 2020, he died. Then,
It's applied mass prior, my lord. Even my lord, case 37, 39, they are held that I am entitled.
Lordship, it was held, Lordship, order, Lordship, next page, Lordship, it has sent to the Principal Private Secretary to the Chief Minister, Lordship. Thereafter, this has come to us, Lordship. Okay. In the instruction, page 4, Lordship, when the Principal, we have sent a reminder from the Deputy Commissioner, Lordship, District Commissioner.
who is going to pay the money?
Is from the Chief Minister's fund.
Chief Minister's COVID-19 widow support scheme was only withdrawn on 18/4/2022. And the reason is different. So obviously, it won't apply to in the case of the petitioner because of the fact that the petitioner's husband died on 16/8/2020. So then, now whom should we direct? Or is it, could we say that these schemes are just made to be shown and then not to pay? Who appears for the Chief Minister's, the Chief Minister's office? Then you have a scheme, people die, and then at the time of scheme, you keep on giving all these promises. Then we don't keep it.
The Home Department has not been made a party, Lordship. Let me have that instruction from that authority, Lordship. Well, because there's a
We make them a party.
Lordship.
Pursuant to the order passed by this court on 16/2/2026, Mr. S.S. Roy, appearing on behalf of the state, submitted that by the government notification dated 18/4/2022, the Chief Minister's COVID-19 widow support scheme have been closed. This court have duly taken note of the said notification dated 18/4/2022 and the reason why such notification was issued. From a perusal of the said notification, it is clear that the government of Assam have closed the scheme in view of the fact that in view of the decreasing number of cases and resultant nil fatalities due to COVID-19 in the state. It is very pertinent to take note of that the husband of the petitioner expired on 16/8/2020. And thereupon, the application was filed seeking ex gratia in terms of the Chief Minister's COVID-19 window support scheme. And this application was also approved and endorsed by the District Commissioner cum Chairman DDMA, South Salmara Mankasar, as is seen from the records. This court further takes note of the parties, the respondents who have been impleaded. But the office of the Chief Minister Assam have not been impleaded under whose aegis? Aegis, AEGIS. The Chief Minister's COVID-19 widow support scheme was announced. Accordingly, this court, therefore, for the interest of justice, includes the office of the Chief Minister Assam, represented by the Principal Private Secretary to the Chief Minister Assam, having his office at Dispur, Gauhati, 781006 as the respondent number 7 to the instant with petition. Mr. S.S. Roy, the learned counsel government advocate, submits that he can accept notices on behalf of the newly impleaded respondent. Extra copy of the writ petition be served upon him by the counsel for the petitioner during the course of the day. The counsel for the petitioner is further directed within 7 days to file a fresh memo of parties before the registry of this court. And the registry shall make necessary changes in the cause title as well as also update the same in the CIS. List this matter again on 6th of April 2026, on which date Mr. S.S. Roy, appearing on behalf of the respondents and more particularly the respondent number, newly impleaded respondent number 7, shall provide the necessary instruction as to why the sanction has not been granted for disbursement of the amount to ex gratia amount to which the petitioner claims to be entitled. And the documents so placed before this court by Mr. S.S. Roy is kept on record and marked with the letter X. And what is this? Again, IMFL lawyer. How many IMFL shops? Mr. You seem to think I'm now expert in IMFL.
We received the instruction. We just need to file the affidavit, your lordship. Instruction received, your lordship.
in this matter.
What is the case?
I am the highest bidder.
There is a private note.
They have cancelled my, they awarded to the Malot third highest. And private husband also appeared in Malot.
नाम लिखो।
Online sir, ये
Officer नाम लिखो।
settlement has been given in favor of somebody else.
Yes, private husband number 5 man. Husband number 5.
And whether the service is complete,
No, he appeared in the very first day, madam.
then
Caveat, he was on caveat.
There the caveat file, he was, madam, he was putting the stay order and then madam put till to the no affidavit in file.
we do one thing, we pass a stay order. He will appear then.
Let me file an affidavit, Lordship. We'll file an affidavit. Department will file an affidavit. We received the instruction, Lordship. As per my instruction, license already been issued, Your Lordship.
So we stay it, then he will appear. Not to function, because there is a 50 meter, na?
Madam,
Within 50 meter, there is another shop, some nursing.
nursing home. That is, they say there is a 30 bedded, my lord, but 30 bedded subsequent to my lord, my opinion of technical treatment.
Huh?
Earlier it was 15 bedded, my lord. That's what it is, my lord.
Now it is
Now it's 30 bedded.
They say
1-3.
30.
30.
So it
So-
becomes more than you can have a one shop.
Normally becomes 30 bedded, it attracts a rule, Your Lordship, that no wine shop can be established in a private hospital which has 30 bedded, Your Lordship.
So then what are you doing?
We are not issuing license to the petitioner, Lordship. It was,
Oh, he was the highest bidder.
he was the highest bidder. He was disqualified by the speaking order, Your Lordship, given by the DC.
Okay. Chalo. When are you filing it?
Within 2 weeks time, Lordship.
Mr. R.R. Gogoi, appearing on behalf of the Excise Department, submits that the affidavit, he has received the instructions and the affidavit will be filed within a period of 2 weeks. This matter again on 8th of April 2026. In the meantime, all the respondents are directed to bring on record their stand by filing the affidavits on or before 30/3/2026. Petitioner granted liberty to on or before 27th March 2026. Petitioner granted liberty to file a reply if so desired. Mr. T.J. Mohanto, the learned senior counsel, submits that there is an urgency in the matter, taking into account that there is no interim order. He further submits that in the circumstance no affidavit is being filed, this court may consider passing of interim directions. This court has given an anxious consideration to the said submission and is of the opinion that if there is no materials placed by the respondents on the next date, taking into account that the notice was issued by this court on 24/9/2025, this court may consider passing of interim directions.
Okay.
I gave it, taking into account then when you have an expert in
No.
IMFL excise matters, appearing, you have to be.
But they are not allowed to meet by the function. Till today.
It has been declared as protected under what? Protected monument under what? Archaeology?
Lordships. Well, it is not clear in the instruction. So might
Will
be in the
have
archaeology,
far-reaching
but
consequences.
otherwise, the 1959 Lordship is the archaeological.
The moment you are saying that, all houses within 100 meters will go away. Are you seriously thinking about that? That it is a protected monument as per archaeology? Writing whatever you feel like doesn't make any.
The Assam Ancient Monument and Record Act 1959. The Assam. Patta.
Our prayer lordship only 2 days in a year to offer namas. Hindu Juha and Hindu Festival. That is our prayer. And that is already decided by page 32. There's a decision, page 32.
Very
In the last page, that decision is there. Next page, that the park shall remain open without entry ticket on the following occasion. Birthday of King Sarpanda Singh, 24th May.
It will be free for open, but that doesn't say that it will be allowed to be operated for
Even the
offering namaz.
Samadhan. Nothing else.
Sort Puja also, my lord.
It's free. Otherwise they will be asking for money. The park.
Yes.
But that days it will be free. It is also in Rongali Bihu. But do you mean to say that inside there is Rongali Bihu? No.
Only Sort Puja also.
was there earlier.
But Puja is closed.
So this decision taken.
No, this decision is there. But the fact is that you can very well on the date of Eid, you can very well go and visit free of cost.
No, that's a only pay one namas.
But namaz, how do you allow it to have a namaz on that day out there inside a monument?
No, there is no monument. No, there is no one monument, lordship. Because lordship.
And they have declared it as a protected monument. That is the question out there.
No, but because till today we have not received such type of because our communication is first is the allotment rate, kindly see the letter 41 letter, that is page 21. There is no monument. Page 21.
And this is an allotment of land on the bank of Naupukuri.
On Idgah.
Yes, this is.
Yes.
You see, there's
Second page.
no for that inside the Idgah, there's no problem. Are they not permitting inside the Idgah?
No, last opinion because verbally that is why we filed this petition. Continuously we prayed for 2 days. It was continuously up to 25th to 2005. 2025, DC asks us because some of the local people, they have demanded to stop this due to this political situation or something. So DC requested us, it is verbally, they're not to offer namaz this time, you just offer namaz inside the mosque. So that is why we asked the deputy commissioner, what is the problem? Well, it may create a law and order situation. Law and order, it is the state subject.
But here they don't say. Give me a copy of the communication.
Only on that ground, because DC has requested us not to perform namaz for 2025. That's why we request was honored, and we have performed the namaz inside the mosque. And so our prayer only for 2 days
prayer. Just like in Maspa Idgah here, all the other activities are going on throughout the year. But only the day of Eid, it is allowed for performing namaz. Maspa Idgah, then Islampur Idgah, the same thing is going on. Throughout the year, activities are going on. We have known this. You have a look at this communication. Let's have it on Monday or Tuesday at 2 p.m. Because anyways, Eid is there on 21st. On 2 p.m., we'll have it on that day. And let's see on that day you produce that letter, that order.
2018 lots.
Because one thing I find it very difficult to appreciate, Mr. Hendik. On one hand, you are saying it to be a protected monument. If it is a protected monument, how can you allow it for Motok and Morans? You cannot allow them also if you take the stand that it is a protected monument. It is to be barred to everybody. I don't agree with what Mr. Rahman is saying as regards that particular communication, which is at page 34. Because the 34 is another different thing. That is a form of a park which is being allowed. On that day, you are not going to charge anything for that. That doesn't mean that they would be able to offer namaz out there. That's not the question. But if you are saying that it to be a protected, then it is protected for all, irrespective of any caste, creed, or religion. So therefore, be ready with this particular document on that date, as well as this particular act. Because the moment, if it is under the archaeology, it has another far-reaching consequences. And that is another very big issue. In the radius of 100, and all the houses will go. Yes. There cannot be any construction.
There is no houses nearby this area.
Are you saying for 100 meters there is no house near the Naupukuri?
These are there. From being under the boundary, I think no residential area is there.
Are you saying when the moment it is a protected monument, the boundary of that protected monument from there, 100 meters on all sides, is a no construction zone? Only construction, the entry of the entry. But as I could remember, this Naupukuri, it has a lot of a residential within 100 meters. As the crow flies, it is not by the twisting bylanes of Tinsukia, which you will see a lot. Pursuant to the order passed by this court on 25/2/2026, an instruction has been placed by Mr. J. Hendek, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the Naupukuri area, Naupukuri has been declared to be a protected monument under the provisions of the Assam Ancient Monuments and Records Act 1959. This court further takes note of that on one hand, a stand is being taken by the district magistrate Tinsukia that it is that Naupukuri area is a protected monument. The Naupukuri is a protected monument. And on the other hand, permissions is also given to certain tribes, that is Motoks and Moran communities, certain communities that is Motok and Moran communities, to host events within the premises of Naupukuri. The question is as to whether such selective actions would be permissible. List this matter again on 10th of March 2026 at 2 p.m. On the said date, Mr. J. Hendik, appearing on behalf of the District Magistrate Tinsukia, shall produce before this court the order dated 28/2018, referred to in the communication, which is marked, which is kept on record and marked with the letter X. A copy of the communication has also been furnished to Mr. H. Rahman, the learned senior counsel, so that he is also in a position to make appropriate submissions on the next date. Mr. Rahman, the thing is, it may not give you the right to have offer namas. It may only stop others from using it.
That was also stopped.
Understood. Satpurza may have been stopped, but you cannot allow anybody there if it is a protected monument. Yes, what is this?
Receive instruction on.
Item number 20. What is this matter about?
Matter related to lordship, non-issuing of the NOC lordship for inter-religious land transfer. And I have challenges the impute office memorandum lordship.
It's
Fine.
the SOP dated 9/9.
9/9/2025.
25.
You have challenged that SOP.
SOP.
You have challenged it.
I have challenges.
Is an SOP law.
SOP is issued.
My question is an SOP a law?
Cabinet decision not.
What is the cabinet decision? The cabinet decision is not law. And what does Article 300A say? No right of a person can be taken away by without, except by authority of law. SOP is no law. Then set aside.
Pass any appropriate order, lordship, but I received the instruction on lordship. If lordship allowed, and I can file that. Lordship can pass any appropriate order.
Now the question is, have you informed him about the SOP? Because of the SOP, we are not granting you the permission because 21A still remains as it is. You have to do it within 30 days.
Use the SOP, lordship.
Where is that SOP?
For 60. The act of
Page number?
60. Petition. Guidelines are there.
It's not an SOP, it is a notification.
Yes, lordship. They have silences.
Madam, you file your affidavit in this regard. Let him file an affidavit because this notification is in violation of Article 14, 19, all. This type of notifications cannot be allowed to. The constitution has to be amended. Preamble has to be amended, everything. Miss So-and-so, appearing on behalf of the Revenue Department, has placed before this court a paragraph comments. So it is the opinion of this court that taking into account that there is a challenge to the notification dated 9/9/2025. The respondents herein is given an opportunity to defend the said notification by filing an affidavit. Full. Non-filing of any affidavit by the respondents would be solely at their risk. This court further takes note of the submission made by the learned counsel appearing on behalf of the petitioner. The rights under Article 300A of the Constitution have been infringed. List this matter again on 23rd of April 2026. A final opportunity is given to the respondents to bring on record their stand by filing their affidavits on or before 1st of April 2026. Liberty given to the petitioner to file reply thereagainst on or before the next date.
Hello.
You take this. I'm not going to.
From the case that my lord, I am the respondent number 8, participated in the last Panchayat election. And I am respondent number 8, my lord, participated in the last Panchayat election. And in the said election, respondent number 8 was respondent number own, my lord. And thereafter, I could learn that respondent number 8 have 4 children. Out of 4, 1 children was born on 2012-2020, my lord. Therefore, I made a complaint for the district commissioner, my lord. And then that complaint, my lord, an inquiry has been conducted. On that inquiry, it was found that her fourth child was born after the cutoff date, it is 2018, madam. And therefore, she was removed from her post. And that order was challenged by the respondent number 8 before this honorable court. This honorable court, your lordship, interfere with that order because not proceeding as per the law, madam. And that, but given liberty to the district commissioner to furnish all the inquiry report as well as the complaint to the respondent number 8, and thereafter I conduct a hearing of the respondent number 8 and I, because I made the complaint, and proceed with the case. But that was not done, madam. Therefore, I have left for this honorable court, madam. And honorable court has issued notice, madam, and thereafter still no affidavit has been filed, madam.
Panchayat? We dismiss your petition. 3 paragraphs. We dismiss your petition. Chalo.
There is the liberty, madam, nothing has been.
So what? You have no business out there. Why didn't you file an election petition?
There is a provision, my lord. If there was more than my lord 2 child, then my lord.
So what?
That can be removed and.
Was the child born after the elections or before the election?
But practice provided in the.
I'm asking you, was the child born before or after?
Before election.
No,
But
matter
is
what.
provided in a rule, my lord, that.
Okay, let me write.
For it, my lord.
No, Dismissed.
Because rule, my lord, in rule 62, 1E, my lord, was said, my lord. May I read, my lord, for a moment?
Which one?
Assam Panchayat Constitution Rule 1995, my lord.
Okay, let me show you what it is. First, you see 243F Constitution. You have it? You are arguing this matter without a constitution. Sorry, state of affairs. It is there in this book also. Chapter 9. Isn't it there? 243F. Anyways, I'm dismissing this type of petitions on 13th. Let me dismiss it on 13th. This 13, unlucky 13 for you. Okay. On 13th, I'm dismissing your petition. This is a ground of improper acceptance of nomination. Article 243F says disqualification for membership. There are two things. First, Article 243F1 says that a person cannot be chosen or and being a member of the Panchayat if he is disqualified, if there is a disqualification which is the same disqualification as to be a member of a legislative. Meaning thereby, you go back to Article 191. 191, the moment you go to Article 191, 191 A, B, C, D says these are the various grounds. E says by any other law made by the Parliament, which means the Representation of People's Act 1951 applies. Okay? Now, if you see 243F 1B by any other law made by the state legislature. So therefore, you have the Panchayat Act of 1994. Panchayat Act of 1994 says about 111, isn't it? Now 243F2 says when a question of disqualification comes, it has to be referred to that particular authority who will decide, isn't it? Now this same provision is there under section 111(1)(h), isn't it? Which says that when a question of disqualification comes, it will go to the authority. It will to be referred to the authority in the manner stated, in the manner as per the law made by the state. Now, as regards 111(2), there is a law made by the state which is Rule 62, isn't it? Now, if you see 45Z of the rules of 1995, it says the Representation of People's Act will be applicable. Okay. Now, 129 of the Act says that no challenge to an election shall be made by in any other manner but by filing an election petition before the election tribunal, isn't it? Now, this is not on the basis of an act. The provision is also there in 243O of the Constitution. So there is a bar. Now, here is a case that this particular person, you are going under 111(2)(a), isn't it? Which corresponds to 62(1), isn't it? So therefore, if a person gives birth to a child after 19/3/2018, more than 2, he is disqualified, isn't it? The moment he is disqualified on the date of the nomination, because If he is disqualified on the date of the nomination, then this is to be looked into as per Rule 22 of the rules. By whom? By the officer authorized while scrutiny is being made. He has the power to accept nomination, he has the power to reject nominations. If it is a power to accept and reject nomination, it comes within the ambit of election as per Punuswami's judgment in 1952. And if that be so, and it can only be challenged by way of an election petition, how does the district magistrate have the power to decide? It is only in respect to subsequent disqualification where the word and remain would come. So we dismiss.
I will.
Mr. Dutta, I'll give you the judgment. I'll ask him, he will give you a copy of the judgment. Therefore, no case. The council, 13, unlucky. Another 13. I've already stacked up many matters along with you. So you only won't be the only one. Others. Let this matter be listed on 13th of March 2026 along with give that for disposal. What is this, Mr. Gogoi?
Freezing of bank account. Illegally freeze.
Bank account, what has happened?
What starts bank account or bank account freeze.
Freeze by whom?
Paying of total.
Why you are freezing it?
Number 1 and 2 are press signature of Omila International Private Service.
Who? No, who has freezed it? All your bank accounts. Why?
Whatever loss it respond number 12 is the appointed by the project manager. Gauhati transfer manager, the railway contract. And to some Chairperson Khan lordship. He had acknowledged that and exercised C lordship.
How are you freezing it? Who is freezing it?
I'm respondent number 12, Your Lordship.
Who are you?
I'm respondent number 12, Your Lordship. I'm the employer of the petitioner's company, Your Lordship. During my course of employment, Your Lordship, I noticed, Your Lordship, some anomalies committed by the petitioner's company, Your Lordship. Your Lordship, regarding misappropriation of public fund, Your Lordship. What happened, Your Lordship? They were engaging fake laborers to generate to generate funds, Your Lordship, which I have.
What laborers?
For the execution of the contract work, Your Lordship, which were not and by generating fake ID, Your Lordship. They were misappropriating public funds, Your Lordship, for which I submitted a public complaint, Your Lordship, before the National Vigilance Commission, Your Lordship. And subsequent to that complaint, Your Lordship, the account has been frozen. I have filed
Who is appearing for police?
affidavit, Your Lordship, which is not in record, Your Lordship.
Who is appearing here for the cyber cell? Okay. Now, who has directed freezing of the account?
It's not, it's by the respond number 3, Lordship.
You have not done it.
Lordship, can you please?
Who has done it? You are which bank? Okay. You have freezed it. Why?
Respondent at 12 and 14 lodge and complaint.
Ministry of Home Affairs. Who is appearing for the union? Yes, what is this? Why have you frozen? The whole matter. 2025. Freezing 2025 is a very old matter. Get your instructions. Two instructions. Whether you are entitled, how can you freeze it? Under what provision you are freezing it? You can just do it like this. Is it done under 106 or 107? And if it is 107, it is required of an order, which is not so. So it is whether it is done under 106. And if you have done it, have you taken the permission which is required from the jurisdictional magistrate? That's it. Get your instructions. Full stop.
Interim pay amendment considered. Interim pay amendment considered.
Eh?
Interim pay amendment considered.
For
Lordship, actually, Lordship, respond number he into running his business also. The operator of Bhavani.
no, we cannot consider you. I'll fix it for disposal next week. Then the petitioner herein is aggrieved. Petitioners herein are aggrieved by the actions on the part of the various banks for freezing the bank account, their bank accounts, on account of certain complaints filed by the respondent number 12 to 14. Mr. J. Hendrik, appearing on behalf of the respondent number 3, had submitted that the said freezing had not been done at the behest of the respondent number 3, but as per the information was done it was not done at the behest of the respondent number 3. Full stop. This court inquired with Mr. S.S. Roy, appearing on behalf of the respondent number 2, 1 and 2, as to whether the Ministry of Home Affairs, to whom the representation was submitted by the respondent number 12 to 14, have frozen the bank accounts, and if so, whether the provisions of the mandate of law was followed. Mr. G. Gogoi, appearing on behalf of the petitioner, expresses extreme urgency, taking into account that the petitioners, more particularly the petitioner number 3, is not in a position to carry out any business. List this matter on 13th of March 2026 at 2 p.m. Mr. So-and-so, S.S. Roy, appearing on behalf of the respondent number 1 and 2, shall produce before this court the instructions in this regard.
I find affidavit, Your Lordship, that
You have no business. What business you have? You have raised your complaint, it is okay. But if these authorities, they don't do, then you file a writ petition and come over out here. What is this?
they are supposed to file an affidavit. In fact, Your Lordship, we have filed an additional affidavit. Some of
Okay,
the
Mr. S.S. Roy, appearing on behalf of respondent number 1 and 2, submits that some time may be granted to file the affidavit. What is this
Your
matter?
Lordship, this is Your Lordship, we have challenged the acquisition process initiated under 1964 Act, Your Lordship. The ground that they could not have invoked the power under that particular act, so far as the purpose of this acquisition is concerned.
You got to stay.
No, there is no stay, that is
And
why.
what has happened?
Lordship. That's in the meanwhile, Your Lordship, so far as some of the petitioners are concerned, land that has been acquisition has been released. I have filed an additional.
Released.
In respect of some of the petitioners, not all.
That means that he will file the affidavit within
2 weeks, Lordship.
2 weeks. List this matter again on 30/3/2026. In the meantime, the affidavit be filed by the state respondents on or before 23rd of March 2026. Mr. Botako, you have an interesting point on this, whether 64 Act would apply or not. It's a very interesting point. And in fact, the rampant use of the 64 Act,
Yes.
thereby bypassing the mandate of the Right to Fair Compensation Act, is also another thing.
Lordship, and this, otherwise we have received our instructions, Lordship, and our comments.
Yes, what is your instruction?
Chief, we have admitted bill amount of 2 months. Already that proposal has been sent. And other part, Lordship, as per our instruction, Lordship, they have not submitted the bills. Lordship.
You do one thing, as none has appeared today. Okay. Heard, none appears on behalf of the petitioner on call. On the other hand, Mr. S.R. Burwa appears on behalf of the respondents. He has produced before this court an instruction dated 6/3/2026, issued by the Senior Superintendent of Police, West Karbi Anglong, Assam. The same is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the petitioner had submitted bills of an amount of rupees 1,21,956, which is under process. It is also mentioned that there is no higher charge bill submitted by the petitioner for the period from 1/2/2023 to 31/5/2023 and 1/11/2023 to 36/2024. Taking into account the said instruction and the fact that the petitioner is not represented, counsel for the petitioner is not represented, this court for the ends of justice adjourns the matter to be listed again on 22nd of April 2026. It is observed that in the circumstance the petitioner is not represented on the next date, appropriate orders shall be passed.
Obliged.
D. Gogoi. What is that? Non-payment? Yes, Mr.
Lordship, my instruction was received on 6/2/42, Lordship, and it states, Lordship, once the fund is received, Lordship, his bills will be processed. Lordship.
Hello, we passed the direction that to the effect that, but is he entitled to?
Yes, Lordship, that completion certificate has been given, Lordship. He is entitled to a amount of rupees 20,67,000.
Okay. He's entitled to an amount of rupees 21 lakh, 20,67,930. To dispose of within 6 months. 6 months.
Lordship.
Can pay. Can you pay within 6 months or not?
Lordship, demand proposal has already been moved, Lordship. But
So you pay within 6 months.
Lordship will pass the order. Let's see, Lordship, whatever.
That is what I'm passing. This type of orders I don't dictate. I think they are fit to 20 lakhs or to silo. Supposed to. What is this, Mr. B. Sharma? You are what's your name? You're B. Sharma?
Yes, sir.
Okay, what is your case?
I am agreed by the not abiding by the notification dated 17/3/2016, madam. This is page number 35. Operative part start from the page number 37.
Framework for revival and rehabilitation of micro. Now, what do you want?
Yes. Para number 2, madam. Identification of inception statement. The identification by the bankers or the creditor before.
Yes, you have filed affidavit.
I am appeared, Lordship. The loan account was classified as NPA on 16/10/2025.
Then
There is no credit entry in the loan account since August 2025. Until today, they have not deposited any.
NPA, what is there?
my grievances is in respect
Now,
of not
Lordship,
following up the-
we have
If
given him letter.
if the government who have issued the notification, let them make the payment to you.
We have given him letter. Now, this letter,
No, Mr. Counsel, I think you should put it on affidavit. You put it on affidavit.
Yes.
Mr. So-and-so appearing on behalf of the respondent numbers 1 and 2 submits that an affidavit would be filed in respect to the present proceedings. So taking into account the above list, this matter again on 8th of April, 2026.
oblige.
Affidavit be filed on or before 1st of April 2026. Liberty
Yes,
given to the petitioner to file reply, if any.
Entry model.
What interim order?
Entry model is there.
What interim order can be there? You are an NPA.
NPI account, Lordship,
No,
we
no, my lord, so far.
Oh, interim
so
order
far-
actually
Yes, my lord,
petition.
last occasion, my lord, on 30 January 2026. After considering all aspects. There is a
Lordship,
even.
I
after-
object.
Well, the proceedings undertaken in respect of where declaring it same to be still remains.
The
Shall
account
we
is Lordship,
stand
and
in the
we
next
are,
Shall
this
remain
writ application is just to protect him from
declaring
enforcing
it
surface
same
action.
to be an NPS shall stand, remain stand. What is that meaning?
My lord.
What is the meaning of the interim order?
My lord, so far this notification dated 17/3/2016 is concerned. That says for declaring MSME account NPA, there is a certain rules. They have to follow those rules. Since they have not followed those rules, we have before this honorable.
You have?
Before the honorable court. My lord, kindly come to the page number 37. my
The
lord. There is a
council
certain
appearing
rule.
on behalf, do you want that I should write it? The council before, I'll put it out here. If you want, you can ask, I can remove it also. The council
No,
appearing on behalf of the petitioner submitted that the interim order dated 31/2026 should be extended. This court have duly perused the order dated 31/2026 and taking into account the submissions so made, this court is not inclined to extend the same. Do you want that or not?
Not.
Next.
But my lord, so.
Absolutely no, absolutely no. Question does not.
They will take action against me.
Yes, another matter. Where is Mr.?
Okay.
I have not received it.
What is this, man? This is some Panchayat? No.
Lordship, contact.
Yes, what is this?
Council, this amount, sir, is.
Some impugn, interim order is passed.
With the quorum, my lord, we have established that the four will be sufficient, my lord.
Four.
Four.
You need
In the present case, already four was present.
7.
Yes, the district commissioner's interpretation was 7, my lord. But this honorable court, including division bench, my lord, has already observed that 4 is sufficient for quorum, my lord.
For out of 10.
Yes.
10?
So in my understanding, this,
How can 4 be per quorum?
because the
10.
language is like that.
Your language of the act is very dangerous. Yes,
Yes,
tell
ma'am.
me.
That was interpreted by the division bench, my lord.
Where?
Uh,
Section?
My lord. Rule 46. Rule 46.
How?
The some Panchayat administrative
Panchayat?
constitution rules.
40?
46.
Election to the deputy
Yes,
commissioner or the
46
so and so as the case may be shall call the first meeting of the compulsory by fixing a date of so and so. If 1/3 or more of the total members of a call
46(3).
the meeting under sub rule 1 are not present within an hour of the time fixed for the meeting, the deputy commissioner, as the case may be, shall adjourn. 1/3 or more. So out of 10, 1/3 or more will be more than 3/4.
My lord, Lordship may kindly have page number 63. Page number 63 of the petition.
This is the order of the division as well.
63. Yes.
My lord, the starts with the argument. starts
According
on
to
behalf of-
Imania, 46(3) and a year does not run counsel for any meeting of year. Yes, in the present case, in a 10-member remand, the first meeting was held on notice where 6 members were present. Meeting is sufficiently to go ahead with the election. Only on then there was election. The decree of the issue cancelling the proceedings and interfering with them as having become the precedent of. For this reason, the learned raising the set. No election could be held. Only 1/3. Oh. Argument. I don't understand the logic behind that page 63. I don't understand the division bench there. You see, what is mentioned out here? If 1/3 or more of the total number of members called for the meeting under sub-rule 1 are not present, means it may be in a 10, 1/3 will be 3 or more.
Yes,
So 3 or more, 4.
yes,
If they are not present in a 10-member or 5 or 7,
yes,
then it will get adjourned.
yes.
Meaning thereby, it has to be 7.
My lord, the interpretation of the division bench is that, my
And
lord.
this is very difficult to understand, page 63.
My lord, my lord, division bench understanding is that, my lord, that the minimum quorum is if the 1/3 has to be present.
But what was the word or more?
1/3 or more, my lord. Minimum 1/3 or more has to be present.
No, no, no. You see, that is the biggest problem. If 1/3 or more of the total number of members called to the meeting under so and so are not present,
Yeah.
meaning whereby it is more than 3 or more. You see, it should have been or less.
Well.
Problem arises is it may also be 7 also.
Yes, all 10 can also.
So the minimum is in a 10, it has to be 3. Out of 10, it has to be 3. If 3 is not present, 3 is absent out of 10. Now, it has to go the other way. If 3 is absent or more than 3 is absent out of 10, then it has to be adjourned.
There are two sides, my lord.
Because here, you see page 63, the court only says no elections could be held if 1/3 was not complete. How does it mean, 1/3 is not complete? It says it appears to be absolutely not right. This order cannot be right. I think there's something must have been wrong, because otherwise, admittedly, 6 were present at the time of year. So if it is 6, how can it be proper in a 10?
Yes, my lord. I am also confused when first I was.
Because this is very difficult to appreciate this aspect, because it says 1/3 or more of the total number of members called. Means if it is in a 10, if it is 3 or more is not present, then it has to be adjourned. If it is 2 or more than 3, see, it has to be more than 3, because 1/3 will be 3.3. In 10, it is 1/3 will be 3.3. So 3 or more. So therefore, 3 or more is not present, it has to be adjourned. And here it is found as 7.
Six.
Yeah,
Sorry, in that case, six was present.
the declaration was on that interpretation made by ER that where the total number here, the minimum quorum for the meeting is 7, and in the meeting held on so and so, there were only 4 members present.
Seven was interpretation of district commissioner of clause 3.
Huh?
The 7 quorum was interpretation of district commissioner of clause 3.
Ah.
But division bench interpretation is 4.
Division bench made some mistake. Do not run counter, and for any meeting of a government, the quorum would be 1/3 of the total member. How is it possible?
But already
Let us see 18.
it has become finally.
Because it would have a far-reaching consequences. You don't have a majority.
But that is only for election.
President of the
president.
election. So that means tomorrow you don't call others also. And you
But they
don't-
already, that may be either case, my lord. Different case,
far-reaching
if notice
consequences.
will not serve, my lord. After submission of.
The quorum of a meeting of the Gaon Panchayat shall be 1/3 of the total members of the Gaon Panchayat. Shall be 1/3 of the total number. As per this, it is okay, 1/3.
But
Rule
problem is,
46 states.
order of the division bench, my lord, it's become finally, my lord.
Maybe, but no. Rule section 18 is clear. The quorum for a meeting of the Gaon Panchayat shall be 1/3 of the total number of members. Means
That is,
if it is 4 also
yes.
or
that is
3,
different. That is not applicable to this second.
is not applicable here.
My lord, the normal Gaon Panchayat meetings, my lord. This is a meeting of first meeting for.
First meeting has to be
Yes.
different.
Yes,
46. 46 is different. But does it say that it is for president, it is different?
My lord, this for election, my lord,
At
specifically
every meeting
46
of
three.
the president shall preside, the voting of our questions here. No, shall vote on. Anyways, he has an interim order. We should extend it until further. order.
Election court number 6.
Okay. Your senior is in legs in court number 6. You want to file affidavit?
My lord, receive the instruction, my lord.
Huh?
Doesn't receive the instruction.
Is this matter, yeah, no affidavit has been filed by the respondents in spite of notice having been issued on 28/1/2026. The counsel, Mr. S. Dutta, appearing on behalf of the PNRD department, as well as Mr. J. Hendik, the learned counsel, appearing on behalf of the district commissioner, seeks for some accommodation. List this matter again on 22nd of April 2026. Affidavits be filed on or before 6th of April 2026. Petitioner granted liberty to reply. The interim order passed earlier shall continue till the next day.
PNRD department is not going to file affidavit, my lord.
Won't file? The respondents are given the final liberty to file their affidavits on or before the it would date.
So directed him to appear before the state.
You went out there?
Yes.
What happened?
With the victim, there was a video from parents' worship.
Then what happened?
And next date has been fixed on 19th of March, your worship.
Well, let's have it after 19th of March. It is seen that
But I filed my affidavit in the meantime.
it's okay. Now the member secretary, Assam State Legal Services Authorities is in session of the matter. No?
But also the DLSA order stands. The instructions which we have received from the DLSA is that it was rejected on the prima facie opinion that the FIR which was produced before the DLSA did not have that section read with section 6 of the POCSO Act. It only had section 365 of the IPC.
But the
And
charge sheet?
It's there. I have annexed it.
Charge sheet, what does it
Charge
say?
sheet, we do not have, we have no, that is not before us, your lordships. So
It's
how
okay.
this
Where's the charge
section
sheet?
6 was eventually brought in, trial to fully has something.
The charge sheet, by charge sheet, this is, the POXO Act has been brought in.
Lordship, no one knows. Even he does not know whether it has been brought in, how this provision has come in, because the application was prior to filing of the charge sheet. When the
Anyways, one can't be so technical on that.
Lordships,
Has the charge sheet been filed or not? He says about the charge sheet being filed, Annexure 2 to the petition. Annexure 2 to the petition, it is shown, section 6, POXO.
he has not filed this charge sheet before the DLSA. My only concern,
Good, madam, but the
just to apprise you, Lordship,
fact remains that a person who is asking for an ex gratia, are you going to trouble him?
no, not at all.
Legal Service Authority is not for troubling people, they to aid them.
Lordships,
They should in fact go to him and find out, and in fact try and trace out
is here.
where is the
all of
form
that.
number 5 for the charge sheet and help him. That yes, POXO is there, so you also make that claim on that. Anyways, when the matter is there. Okay, it is submitted by Mr. S.I. Akand, appearing on behalf of the petitioner, that the next date before the Secretary Assam State Legal Service Authority is fixed on 19/3/2026. We'll list this matter again on 31st of April 2026 for an update.
31st of March, 30th April or 31st of?
1st of April.
1st of April, all right, apologies.
Ms. R.S. Chaudhary appears on behalf of the legal service. Assam State. What is this?
That's regarding the
Has claimed that he is the president of so-and-so committee, as there is no subsequent development in the matter of settlement after resolution, the meeting is approved by Yes, affidavit, madam. Take a decision, inform him what is to be done. It is seen that though notice has been issued as far back as on 5/3/2025, there is no instructions placed either by the Revenue Department nor by the District Administration. What does he say? And no instructions has been placed. List this matter again on 25th of March 2026. The respondent shall ensure that the instructions are placed before this court on the next date. What is this? Has Mr. Ardhor's name put out there in the cause list?
shown.
Huh?
It is shown. Was this is shown?
What is your case?
This is the petitioner belonged to Madai subcaste or Lava tribe. They applied for caste certificate. The district commission rejected.
Now, SC/ST, this is being done by that, there's a commission, na? Has the matter referred to the commission or not?
This district commission, they referred to they forwarded.
Huh?
As first we have submitted online application, then they forwarded to the
Committee.
committee.
Then what happened?
Secretary.
Then?
They say forwarded to secretary.
No, when you are asking this, there is a guideline for that.
Yes, guideline is there. Page
Then
45.
what happened?
Page 45.
And then?
We have applied as per guideline.
But there is no
problem that
information.
Our fathers,
Okay.
they do not have the caste.
So we
certificate.
pass an order that we ask the director of this tribal affairs to appear, taking into account that none is appearing on behalf of them. Okay. None has appeared on behalf of the who is appearing for them? Director. Okay. Mr. J. Hendrick appears on behalf of the respondent number 4. But the service is complete.
Respondent
Okay. Oh, wait.
notice not issued to respondent
wait.
5 years.
Why no notice was issued?
What is not required is
Huh?
because already they have
certificate in favor of the petitioner.
Okay.
Page 65.
Okay. None has appeared on behalf of the official respondents except Mr. J. Hendick appearing on behalf of the respondent number 4. It is also noticed that on 17/2/2026, there was a direction issued upon the registry to reflect the name of Mr. Ardhar, Standing Counsel of the Tribal Affairs Department. His name duly appears in the cause list. However, he has chosen not to appear. Considering the above, this court fixes the matter again on 31/3/2026. On the same date, this court directs the respondent numbers 1, 2, and 3 to provide instructions as to why the petitioner have not been issued the STP certificate. A copy of this order, the registry shall furnish a copy of this order to Mr. J. Hendrick, who appears for the respondent number 4, and who shall forward it to the respondent number 3, that is the Director of Tribal Affairs Plain. The respondent number 1, 2, and 3 is given the choice option to either appoint a fresh counsel or they should appear. The respondent number 3 shall appear before this court on 30/3/2026 at 10:30 a.m. with such instructions. Mr. J. Hendrick shall also provide the video link to the respondent number 3 to appear before this court on the next date.
I'm sorry, Malak,
I can't help it.
I apologize, Malak.
I've asked them to change the counsel. Forty.
No, 30
So they have approved on 16/2/2026. Now within
30 days.
after 30 days you have to appear.
Yes.
So
Yes.
nothing remains. We close it.
16, after 16 to go and
We take this on record.
yes, it may be recorded.
The petitioner herein heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Miss N. Bodlow appears on behalf of the Revenue and Disaster Management Department, and Mr. J. Hendrick appears on behalf of the District Administration. Ms. N. Bodlow, Mr. J. Hendrick has produced an instruction dated 2/3/2026, issued by the Assistant Commissioner, Senior Sub-Register, Kamrup Metropolitan District, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the petitioner, there are two petitioners, the petitioner number 1 had applied, it is mentioned that the petitioners had applied for an intended marriage on 29/11/2025, and an acknowledgement was issued. The submitted documents have been verified by the office of the senior sub-register, and the said application was approved by the authority on 16/2/2026. It was also mentioned that from the date of approval, that is on 16/2/2026, the parties have to be present before the marriage officer after 30 days from the date of approval for solemnization of the marriage. Full stop. Considering the above, this court fixes, not won't dispose it of, fixes this matter on 6th of April 2026 for an update. Go and marry and then say infructuous.
Lordship, in this matter, affidavit has been filed, and affidavit has been filed, Lordship, in this matter, and Mr. H. Buragohai appears in for SBI. Lordship, he has to leave the court due to some medical emergency, Lordship. Matter may be fixed.
Why have you done it?
Pardon, Lordship.
Why have you done it?
It was on the instruction, on request from Cyber Cell of Charger Police, Haryana.
When was it informed?
Pardon, Lordship.
Okay, it is Mr. C. Sharma, submits that he has been instructed by Mr. H. Buragohai, the learned standing counsel of the learned counsel for the SBI, that he had to leave the court on account of personal difficulties. He therefore requests this court to fix another date. Accordingly, lists this matter on 11th of March 2026. Liberty given to the petitioner to file any reply in the meantime. What is this?
Well, I have instructions for that.
What is instruction?
Well, Lordship, I asked to,
Why permanent connection not given?
well, we can grant permanent connection if Lordship allows us to give.
Huh?
Well, we have received an objection from the private respondent, one of private party, my lord. That's why.
Why?
But they are claiming that, my lord.
Ah, this cannot be the ground. We'll have it on, you produce this on Monday,
Yes,
we dispose it off.
my lord.
List this matter, Mr. B. Das, appearing on behalf of the Standing Council APDCL, have placed an instruction before this court which is marked with the letter X. A perusal of the said instructions reveals that one Mintu Gogoi had submitted a written objection claiming absolute ownership of the land. And it is under such circumstances, the permanent connection has not been granted to the petitioner. List this matter again on 11/3/2026.
Clerkship, I have some difficulties. Already a matter fixed before the Itanagar bench, clerkship.
Fantastic. 16th of March 2026.
Lordship, in this case, an injury order was passed against the eviction order. Thereafter, Lordship, I have lost contact with the client. And I don't have the recent instruction. I have seen written letters, but they did not respond. Even I don't have the phone number. Thereafter, I have sent a letter by registered for withdrawing my Ukalatnama in this case. Probably the matter has been implemented, they are not responding. This is regarding a plot of allotment of a plot of land in Lahore municipal market. And that market has been redeveloped by this time. New market has been constructed there. So probably they got some relief, that is why they are not contact.
We don't put your appearance, we dismiss it for default. You inform it has been dismissed, then they will come, then we'll restore it. None has appeared on behalf of the petitioner on call. Petitioner or respondents on call. It is also seen that the steps which were directed to be taken by the order dated 10/12/2024 have not been taken. It appears that the petitioner have lost interest in the instant writ petition. And accordingly, the writ petition stands dismissed for non-prosecution. Inform them. Ms. P.R. Mohanto, appearing on behalf of the respondents, submitted that the order dated 14/11/2022 passed in WPC number 4792/2022 have been duly complied with. Inasmuch as an amount of rupees 2 lakhs, the ex gratia, have already been released, paid to the petitioner. In that regard, an instruction had been placed before this court, which is kept on record and marked with the letter X. Taking into account the above, the instant contempt proceedings stands closed. Who is appearing? Mr. Gugoi, you are appearing compliant?
Order is passed, Lordship. Order passed as per court, so that. Somewhat no ideas, no?
This is an application filed alleging willful and deliberate violation to the order dated
Lordship, 4/1/24 also.
4/1/2024 passed in WPC number 6964/2022, whereby this court directed
Paragraph 15, Lordship. Page 72.
the respondent number 3 in the said proceedings to complete the exercise as regards the adjudication of the application to be submitted by the petitioner within a period of 3 months from the date of submission of the certified copy of the order. Mr. K. Gugoi, appearing on behalf of the respondent numbers 1 and 2.
1 and 2, Lordship.
1 and 2, has placed before this court an order sheet dated 22/11/2024, whereby, from where it is seen that the applications so submitted by the petitioner have been disposed of. The same is kept on record and marked with the letter X. A copy of the said order has also been furnished to Ms. So-and-so, appearing on behalf of the petitioner. In that view of the matter, the instant proceedings, contempt proceedings stands dropped. It is observed that the dropping of the instant contempt proceedings shall not prejudice the petitioner to assail the order dated 22/11/2024, if so advised.
Lordship, yes. When the order has been
Complied. It has been submitted that the order dated 26/7/2024 24 passed in WPC number 4476/2023 have been duly complied with. Taking into account the above, the instant contempt proceedings accordingly stands dropped. Mr. J. Hendick appears on behalf of the sole respondent.
May it please Lordship, here we have filed an affidavit for sole respondents on 28/1/2026.
What is your affidavit?
Lordship, here we have forwarded to the concerned authority
Arbitration amount of AN has been prepared towards the visit of funds.
for releasing of the fund. And we are awaiting for that.
What is the order? Which order is given? Challenging? Order has been complied.
Lordship, and we have forwarded to the concerned authority for releasing of the fund on. And we
No,
have-
the direction was to pass an order. You cannot, who is going to disburse?
Specific order in respect of each of the petitioners.
Huh?
In respect of each of the petitioners.
Consider the, yeah, but who is going to disburse? They are found to be entitled the revised in terms with the arbitration amount. Any further? So as per that, you have, the deputy commissioner have already done the needful.
Lordship,
There is no direction to disburse.
My lord, if Honorable Court directed to pass necessary order in respect of the petition, specific order in respect of the petitioner if they are found entitled.
They say that the DC says that he has found you eligible.
He said that he has a petitioner entitled and accordingly made an amount of 32,85,501 for sanctioning of the said amount. He has already forwarded a letter to the.
Better over.
He has,
There is no direction to pay.
this is the disbursing authority. Deputy Commissioner.
No, there is no direction to pay. Where is the direction to pay?
Here, my lord, in the affidavit, my lord, he has specifically.
It is seen from the affidavit filed by the respondent number 2.
Yes, ma'am. It's specific.
That the order so passed by the that the order dated 6/12 in pursuant to the order dated 6/12/2024 passed in WPC number 6487/2024. Is it? Huh? Which order?
6487.
The respondent number 2 have already made the verification and found that the petitioners were entitled for the amount of rupees 32 lakhs have already made the verification and found that the eligible beneficiaries of village Palo Serra Part 2 were entitled to an amount of rupees 32,85,501. And in that regard, the District Commissioner Hailakandi have already requested the Chief Engineer PWD NH Assam Chanmari by the communication dated 26/5/2025 for disbursement of the said amount. It is further seen that there is a reminder also has been issued by the District Commissioner, Hailakandi, on 22/12/2025. It is the opinion of this court that the directions so passed by the learned coordinate bench in the order dated 6/12/2024 as against the Deputy Commissioner was only against the Deputy Commissioner, and the same have been duly complied with. Accordingly, the instant contempt proceeding stands dropped. Liberty given to the petitioner to take action against the respondent, against the PWD authorities in the circumstance, the amount which have been verified to amount which has been held to be verified, to be entitled, is not disbursed.
Yet, at that time, all of the petitioners, my lord. All of the petitioners are entitled amount of rupees 32 lakhs 85,000. Not only Malo.
Huh?
Your lordship will retain Malo only. All of the petitioners, my lord, are entitled.
No, here they have said the
Your lordship
verification.
fine pays, my lord.
No, the verification is made, they didn't say name the petitioner.
Then has been given. Pays 35.
No, 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 no. If you see the affidavit,
Affidavit, yes, ma'am. Pays
affidavit, it says that it is observed that the following individuals, so and so, are included in the original. Consequently, they received a compensation. However, Suan was not included. These matters have been included in the so and so. Accordingly, an arbitration award has been prepared for the eligible beneficiaries of so and so. And this amount is only for the eligible beneficiaries. So this has been done.
name has also been given.
Fantastic, good. Now challenge it. There's no contempt. No contempt.
Petitioner, that may be. The entitlement is all to all the petitioners.
Which includes the petition.
Yes. Not only Malo, otherwise it will be different.
I can't tell you which includes the petition because there is no mention out there that you are entitled to.
Cancel, my lord.
Where?
Here, page paragraph 6. Affidavit 35, page 35.
They are saying that the petitioners are entitled.
Here, my lord. All name.
Are there others also?
Yes, my lord.
So
Page,
the petitioners along with others.
not that only all the petitioners. We have also mentioned that the number of the contempt petition. My lord.
Contempt is closed.
That is otherwise will it
Yes, what is this?
Hello.
What is the review for?
Case number 39.
Why they are challenging?
And subsequent order, lordship, is at place 44. And to that order, lordship, they have already prepared lordship read petition.
Okay, none appears on behalf of the review applicant on call. Ms. So-and-so appears on behalf of
The opposite party number 1.
so-and-so. Taking into account the above, this matter again on, you have been given the contract.
Lordship, I mean, turning the lordship matter now.
Running what?
RTF lordship settlement on
How many years?
1 year.
Okay. When did you get it?
In the month of September.
September, and it is till 36.
Yeah.
Okay. This is the matter again on 4th of May.
Photography.
Leave the matter. What is this they are filing? Leave the matter in on 11th of May. is this counsel? I hope. The instant application is filed seeking a direction for dismissal or the subsequent suit being title suit number 97/2025, which is going on in the court of the Civil Judge Junior Division number 5, Kamrup Metro at Gauhati. It is the opinion of this court that such application is completely misconceived and accordingly rejected.
Back to lordship.
Service upon response number 6 and 7 is not complete.
No, Lordship, 4, 5, 6, and 7. Access
You are
direct
appealing.
and access bank.
What is the matter above? That means service is complete.
Yes, sir.
Okay, service is complete. Accordingly, lists the matter for admission on 16th.
Subject to lordship's convenience.
I am always a clear convenience. 16th.
16th of March. Highly obliged.
May I plead your lordship?
What is your case?
Lordship, actually, an amount of rupees 2,14,000 was fraudulently transferred from my bank account, Lordship,
To
to one
another person.
Subrajit Acharji, Lordship. Subrajit Acharji, Lordship.
Now that amount has been withheld.
Withheld, Lordship.
That account also has you have been asked to approach the SDJM. Why you are not doing it?
Actually, no instruction was given to me, Lordship.
You go there. Okay, hook. Hard, mister. We'll close it up, giving you liberty to go there. Hard, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B.K. Sen appears on behalf of the respondent number 1 and 2. Mr. J. Hendig appears for the respondent number 3 and 4. The petitioner herein is aggrieved by the action on the part of the respondent number 2 to not refund or revert back the hard-earned the money, the amount of rupees 2,14,000, which was wrongly transferred to another person.
Lordship.
Wrongly withdrawn by some other person.
How?
No, Lordship.
That is his case. He says that somebody has by means of fraud.
Okay, we do one thing. No, you see, if it is a case, why should he trouble him again to go to the SDGM if the facts are admitted?
The procedure is that, my lord, SDGM has to.
No, understood. But Mr. Henry, kindly see for yourself. You have 2,14,000 in your bank account. That amount goes to Mr. BK Sen. It was not supposed to go. Now, BK Sen's account is being kept at hold. Now you want the money back. Now you have approached this court, maybe wrongly. But would it be nice for this court to again revert you back to that court, again feel the troubles out there? My only question is this: see the anxiety. It is no fault of him.
But my lord, unless.
Now, if you want an order from the AGCM, wouldn't an order passed by me out here would not help you? My only question is this. Sending him back is no problem. I can very well send, but think about him. Think about you. If your thing has come and you approach this court, and they said, yes, there was a mistake by which it went to somebody's rent's account and it has been kept on hold. You say that if that is so, kindly revert it back to me.
My lord, even the payout to approve before the. Before approve the amount to approve, we will directly to file from the petition before the agreement.
Okay, then in that regard, you must be having some document to the effect. Okay, we do one thing. Mr. J. Hendrick has, in pursuance to the orders notice being issued on 21/1/2026, has placed an instruction which is kept on record and marked with the letter X. It is also noticed that all the respondents have been duly served. Accordingly, list this matter on 13th of March 2026 for admission. Think about it, Mr. Sen. Today, no, Mr. Sen. No, Mr. Sen. Mr. Sen. No, Mr. Sen. Mr. Sen, I'm not going to hear all these things. No. Mr. Sen.
Tomorrow it may create a precedent, or.
I know that. I know that it will create a precedent, it will open up a floodgate, I understand. But the fact that if it is not his fault, for this court to say, yes, notice has been issued, all the parties say, yes, it was wrongly done, then to say, oh, now you go and file it, get a certificate from him. It would be proper. See, we are exercising an equitable jurisdiction also. Would it be proper? Because he has already spent some money. And if it was a fault, we can, on 13th, you also argue another point. If it was a fault of yours, for which he has gone, I will permit him to go to SDCM, provided I impose a cost upon you for the litigation. You come up with your figure. Okay? How much bill you have taken. That we allow. No, he has to come. He shouldn't spend unnecessarily. My question is that.
I understand.
But Mr. Sen, why I said, I asked you to think about it, not because of me. One matter in the morning, you were not there. I today accommodated you.
Due to some, my lord, personal difficulties, my lord,
Therefore, I have accommodated you. Try to accommodate him.
I'll.
13.
Notices have been served, my lord.
Okay, service is complete.
Service is complete.
Okay, service is complete. List the matter for admission on.
I'm appearing for respondents 5, 6, 7.
He's appearing for the private respondents, my lord.
What is the case about?
Well, the case is, my lord, regarding a plot of land, which, my lord, I.
No, we have it on for order admission.
Yes.
Okay. Let's have it on 16th.
My lord,
4
can-
weeks will be granted. 4 weeks.
You are asking for interim prayer?
There is already prayer is there, my lord. That relief is there.
Where is the interim prayer?
My lord, the relief is there, my lord.
Relief is there, but in the repetition there was no prayer.
There was no prayer. We had filed subsequently we had
We
filed.
will not proceed for
additional
demolition of so and so pursuant to the notice.
So there is an additional repetition praying for interim.
Not praying, my lord. We have brought it on record.
Okay, take it. The service is complete. Counsel appearing on behalf of the respondent number 5 to 8. Mr. So-and-so, the counsel appearing on behalf of the respondent number 5 to 8, and Mr. Esbora appearing on behalf of the GMC submits that they would be filing that response. This matter, you want 4 weeks, nah? Not before that. list this matter on 4th of May 2026. Liberty given to the respondents to bring on record their stand by filing the affidavits on or before 24th of April 2026. The petitioner thereupon shall be at liberty to file their reply. Interim order passed earlier shall continue till the next date.
I'm obliged.
May I please, Your Lordship? This is a review, but there is a delay of 550 days.
What review?
A review of Your Lordship's order, because there was an observation in Your Lordship's order that in para 27 of Your Lordship's order, which is not the correct reflection.
On the other hand, I submitted that the said submission was totally misconceived in as much as in the cross-examination of the defendant number 1. Defendant witness number who is the defendant, he categorically stated that the plaintiff did not come to his house on the month, which was the date mentioned in the FIR.
But on the cross-examination, he had admitted that the person had come on that day. It is not the other way around, Your Lordship. And because.
But my question is,
Yes, sir.
this is your submission. But was that made the basis on which I passed the order?
Yes, because the limitation point, Your Lordship.
No, I'm saying, where is my basis? Understand, this court is of the opinion that the issue number was rightly decided.
Yes.
Where is it mentioned?
That particular observation
Yeah,
on the
and what
basis
is
of this.
the evidence in view of the submissions made by the respective counsel, it is seen from the evidence led by the parties that the defendant number 2 stated that
Para
he
29.
came to know about the agreement dated in the year 2004 to be false. On the other hand, if this court takes note of the cross-examination of the plaintiff, it is seen that the plaintiff stated that the year expired in the year 1996.
Yes.
He further stated that after filing of the FIR, the defendant number 2 did not inform him that he would not sell the land. The plaintiff further stated in his cross-examination that he did not remember a year. But it cannot be said that the defendants have proved that the plaintiff had notice of refusal of the performance by the defendants to the agreement dated so-and-so on such other date so-and-so. Under such this court is of the opinion, which was rightly decided by the year below by demand so-and-so, the answer is the first substantial question of law. So, we dismiss it.
With regard to limitation, Your Lordship.
We dismiss the limitation application.
Because of the date was.
No, why you are moving up for 550 days?
Because, Your Lordship, in the meantime, what had happened, he had gone for SLP. He had filed an SLP. But he did not know that after the filing of the SLP, there was a chance of again filing. SLP was dismissed on limine without going into, and he did not know about the right to file.
SLP has been dismissed.
It was dismissed.
Then
Without
taking a leave, can you do it?
There is a judgment of Your Lordship. There is the apex court that even if the SLP is dismissed on without going into the merit, the doctrine of merger does not apply, and so review can be made before the Honorable High Court.
No. After dismissal, you cannot.
After dismissal, it is there, Your Lordship. If I may just place Your Lordship.
And dismissal happened on 6/12.
Yeah, that is the delay.
And you filed after when?
550
Because
days.
you didn't know that.
550 days.
No.
550 days I have filed.
No. We dismiss it. Again, you go to the Supreme Court. Chalo.
Because he did not know about
No,
this.
Mr. I think we impose a cost at 5 o'clock.
No.
Mr. Dhar, I won't put that order like that. Don't look at me. I would not put this order like that in your case.
I was supposed to assist this court, my lord.
Your name was glaringly appearing in the causes.
I was in the courtroom, my lord. Not the court, actually, my lord.
You should have known how this court functions, huh? You should have kept one junior of yours. Well, you don't have any junior. Then have 2, 3. You want juniors? There are many young advocates who now wish to be juniors. Should I refer them to you? Now you would be having the capacity of 5, taking into account the amount of matters. What do you say, Mr. Hendrik? He doesn't have a junior, and he does big matters, big corporation, all tribal, WPT, everything is his case. So we do one thing. Whenever there are many people who keep on asking me that we want to be juniors of here, what should I do? I refer him. For and fixing a stipend also. It doesn't mean that you will only have the junior without that. With that undertaking only, your name is the order would be changed. What was the item number?
45. 45. 45.
When did I fix it?
Any day, next week also. 33.
Mr. Adhor, the Learned Counsel, appearing on behalf of the respondent numbers 1, 2, and 3, submitted that he needs a week's time to obtain the necessary instructions to stop. I'll list this matter again on 16th of March 2026.
Only a notice which I will put pilot and pilot will dispose it. I had to notify.
I am not there on that date, therefore. Okay, now we dismiss your application. And this is not an application. Mr. I know why you are there. There is some case out there. This is not done. This is not done. 2010, you are wrecking out it after this. Heard Mr. A. Biswas, I can't allow this type of.
There was a genuine.
There is no genuine. They cannot be
not
genuine.
know
That
about
is not
the-
the basis of there. No.
They did not know about the
No.
provision of
He
filing.
doesn't know there. There's no mention out there, nothing out there. Heard
That is-
Mr. A. Biswas, the Learned Counsel, appearing on behalf of the petitioner, applicant. This is an application filed under Section 5 of the Limitation Act for condoning a delay of 550 days in preparing the review application filing, in preparing the accompanying review application. File seeking review of the judgment and order dated
14/5/24.
14/5/2024 in RSA number 262/2010. It is relevant to take note of that pursuant to the judgment and order dated 14/5/2024 in RSA number 262/2010, an appeal thereagainst was filed, an appeal under section, a special leave to appeal was filed under under Article 136 of the Constitution.
Page 40.
And the said appeal was dismissed by condoning the delay and the said special leave petition was dismissed by condoning the delay. Thereupon, the instant application was filed, the accompanying review application was filed on.
It was filed on 14/6/20. Sorry, 16/12/25.
16/12/2025. With various defects. The said defects This court finds it very pertinent to take note of the defects by which the review application was filed. They were, number one, the mobile number / WhatsApp number of the petitioner was not given in the filing form. Number two, the annexures were not certified. Number three, one page each in between page number 29 and 30 and page number 30 and 31 and 32 were missing. Number four, condonation petition not filed. Number five, court fee was short by 1.50 paisa rupees. The defects were rectified only on 7/2/2026. Let's see the ground. In the backdrop of the above, this court finds it very pertinent to take note of the ground taken. To show sufficient cause. The ground so taken is that the review applicant was not aware that a review can be filed even after the dismissal of the SLP. It is the opinion of this court that based upon the defects which were maintained, which were the manner in which the defects were put in the review application at the time of filing, and the grounds were assigned in the condonation application, do not appear to be bona fide, but rather an attempt to further prolong a dispute which stood settled. Under such circumstances, as the instant application is not found bona fide, this court is not inclined to issue notice in the instant application. Accordingly, the instant application stands dismissed. When dismissed, a review cannot review, taking into account that, what is this IA? IA খনত order হব আৰু review petition খনত লিখিব
Filing number, it is only the filing
number 1 I know. তাৰ তলত আৰু এটা line লিখি দিব. In view of the dismissal of the instant application, the review application, accompanying review application so filed cannot be entertained. And accordingly, the same also, and it cannot be entertained. First.
Abla-
It will be regarding completion of the special to service complete.
Yes, your lordship.
Service being complete. Matter pertains to
Freezing of account.
Freezing of account. Your Lordship.
freezing.
Yes.
Okay. Service being complete, list the matter on 13th of March 2026 for admission.
Please, your lordship. If allowed, your lordship, 13th may not be given.
Fine.
Because I will not be present, your lordship.
Okay, 11th.
Along with the other matter just before.
11th. 11/3/2026 for admission. Yes, what is it? Complied?
No, my lord.
Okay. This is the matter again on 18th of March 2026.
My lord,
Service is complete.
no, my lord, name is not shown in the cause list.
Let's see what is there. Service is complete. or not. Okay. So then you have to take fresh steps. Take fresh steps. This court have duly taken note of the office note dated 21/2/2026. And taking into account that the service is not complete as regards the respondent number, sole respondent, comma, the petitioner is directed to take fresh steps by way of the fresh steps upon the respondent by speed post within 2 days, by Tuesday. Post. The instant application is made returnable on 4th of May 2026.
Otherwise, my lord, Deputy Commissioner is aware, my lord, about
Eh?
Otherwise, Deputy Commissioner is aware, my lord, about the contempt proceeding, my lord.
We'll do one thing. Mr. Hendrik, you just find out. Oh yeah, there's a deputy registrar. Yeah, okay. Regarding submission of report of 2 NOCs against here, this is being done. Mr. Hendrik, you appear in this matter. There's already an instruction placed by he directly gave to the deputy registrar. It is seen that the district commissioner Hosai have submitted a report, issued a communication to the Deputy Registrar Gauhati High Court on 21/8/2025. And the same have been placed before this court. It therefore appears that the district commissioner is aware of the instant contempt proceedings. Are aware of both the contempt proceedings. এখন আৰু তাৰ next order to একে এটাও হ'ব। This court have requested Mr. J. Hendrik, the learned government advocate, to assist the court in this matter, which he has agreed to do so. List this matter again on 13th of March 2026. Mr. J. Hendrik shall peruse the comments so given in the communication dated 21/8/2025 by the District Commissioner Hosai, which is a part of the instant record. Both are same, huh? Mr. The longest name advocate, AMHR Khan. Your both are same, na?
Yes, my lord, same.
30th.
Service has been completed, Lordship.
Your Lordship, the matter may be disposed of today.
Why?
Because here the amount is only rupees 240.
240 rupees, sir.
240 rupees.
Ah.
Disputed amount is only 240. And in this matter, earlier there is one writ petition, and that was disbursed with direction to keep the disputed amount in no lien account.
Is a lien.
Yes,
With a lien.
in lien, sorry. So, in fact, in that case, I was there.
Where? Where's the order? মই এটা order এটা দিছো এইদিনা। ₹240 এইটো চাই পেলাই এইটো চাই পেলাই বনাই দিব order লিখ okay so dispose it off.
Yes, my lord. Yes. Amount is very good.
নাই
Small
this is
amount.
মই এটা এইটো order pass কৰিছো by keeping a lien on these 240
We-
এইটো
Much obliged.
আমাৰ order আছে চাই no more na